My lord, I want my lord, lordship's indulgence to move a petition, my lord, unlisted, my lord, today, because the matter is fixed in the tribunal on 22nd, and the case has been fixed for final order, closing the cross-examination of the evidence, my lord. So matter was actually listed before court number 6 to yesterday, but the court is not available today. There is an indication that we can seek your permission, my lord, to move today, my lord, as an unlisted, my lord.
What is the urgency source?
My lord, the
Can we take
met,
up tomorrow.
my lord.
Can we take it up tomorrow?
My lord, today,
Can we take it up tomorrow?
my lord, case is fixed in the tribunal on 22nd, my lord.
22nd is which date?
My lord,
Oh,
day after tomorrow, my lord.
so we'll take up tomorrow instead of today.
My lord.
Okay, tomorrow.
May I please, your lordship?
Yes.
With regard to item number 11 of today's list, madam,
Oh,
I have instruction to withdraw this appeal, madam. Madam, this is an application filed against rejection of my bail, madam.
oh, rejection of.
Bail.
Then we can withdraw.
I appear for the NIA motion.
Mr.
B. Prasad.
B. Prasad, Leonard, counsel for the appellant. Please for withdrawal of this criminal application. Start with Mr. A.R.D. Chowdhury.
RKD.
R.K.D. Chowdhury, Leonard. You are the special PP.
I'm the counsel for the NIA.
Leonard, counsel appearing for the NI is present. The criminal appeal is accordingly dismissed on withdrawal.
May I please, your lordship? Lordship, I pray for adjournment of item number 5 of the daily list, my lord.
Have you mentioned,
My lord?
have you given your mention slip?
No, my lord. I am
Why?
my lord, I have been instructed, and I am appearing on behalf of the MAK security, my lord, Mr. P. Mohanta, my lord. He has some personal difficulty today, my lord.
Who appears?
I
You have any objection?
just now inform me, you'll take some
That
time.
is the problem. There's already a notification that you have to inform 1 day ahead.
My lord, I am aware
I
of
don't
it.
know why you are doing all this.
I seek an apology, my lord.
Okay, on request, madam.
And in this matter, your lordship, may I submit? Lordship, some of the depositions were taken up in the court of your lordship, Miss. Some of the depositions I have seen. Whether your lordship take up, a judgment was given by somebody else.
Okay. List this matter before any other bench without one of us within bracket. You
Two
put,
matters today I have found, which I have dealt with.
within bracket, you put sister's name. Okay.
Public.
May I please, Your Honor? I beg to mention item number 6 for the adjournment, as the amicus curiae for that case is not well today.
Here also no mention slip.
I received the information today, today morning only.
Yes, Boyan. Okay, on request made on behalf of Mr. A. Tiwari.
Yes, Your Honor.
Leonard amicus curiae list the matter after 2 weeks. MSB Boyan Leonard addition BP Assam is present.
May I please, Murada? 3 matters, Murada, some urgency is there. May I pray for listing, Murada, on 26th of this month, Murada, after vacation?
3 matters
Yes,
for hearing.
for heading.
Okay.
Obliged.
Item 1 of daily list, hearing.
Yes, what is this case all about?
Mala. There's an appeal
Hmm.
by the prosecution, Mala,
Yes.
against the grant of bail
my lord, the impugned order is at page 87.
Page
87, my lord.
yes.
Bail application is being filed by the so and so for release of the other bail application so and so by Srimati Ika and I by Srimati Ika for the release of his step and bail.
Anybody for respondents?
Madam, notice was served and the list shows that the respondent names are there. But
Where are they?
last time also the same last order yellow.
Last order, the same thing happened.
Nobody appeared for the respondent. Their names are shown there. Names are reflected in the cause list, my lord.
So what do? We proceed? Or shall we give them one last chance?
My lord,
Should we proceed or we give them one chance?
charge, my lord, that is under UAP Act, my lord.
Yeah.
UAP Act.
No. Should we allow the respondents one more chance to appear?
Oh, your lordship wants to give one more chance.
Yeah.
Up to your lordship, my lord.
You heard Mr. D.K. Das,
Dikeda.
Learned Senior Counsel, assisted by MS
GD Chowdhury.
D.T. Chowdhury, Learned Counsel for the appellant oblique NI. None appears on behalf of the respondents. List the matter again after 1 week or 2 weeks?
2 weeks.
2 weeks. Can you inform them?
He will correct. My lord, let us see. We will try.
Yes, they are from here only.
My lord. And they are from here, my lord.
Yes.
At least I think one of the advocate is from here. I don't know.
Correct.
We'll try, my lord.
Item 2 and 3.
Hey,
The counsel appearing in item number 2, I had a talk with her yesterday. She was ready with the case. Today she is.
I'm for
little late.
3, Lordship,
But
but
same matter, she is
the
for
same judgment. For 2, someone else is appearing, Lordship, and for 3, I'm appearing.
Item 2, she's not present today?
And she'll come. We spoke yesterday and then she was ready with the case.
Oh.
She'll come. Let her start. I think I don't know. I mean,
Supposing she doesn't come,
Lordship, pardon, Lordship, I can't.
supposing if item 2 does not come, does not appear.
Yes, that of course. This
But
is father and
my
son.
argument will be for both
Let
of
us
them.
do one
Lordship.
thing. We'll take up the other matters, wait for some time.
Okay.
Yes.
Okay, fine,
Let's see
Lordship.
if she comes.
Fine, Lordship.
Four.
May I please, your lordship? Hello? My lord,
Yes.
may I start?
Yes.
Yes, sir. My lord, in this appeal, the appellant has been convicted under section 302 IBC and sentenced to life imprisonment, my lord. My lord, in this case, the case is that may I read out the FIR, my lord.
Yes, where's the FR page?
The English translation is like this, my lord, at page 4 of paper book, my lord. I have the honor to state that around 5 p.m. on 24/4/2013, the above named accused killed my 26-year-old son, Sri Nasu Nayak, by hacking him on his neck and head with a dao over the matter of a catapult. I therefore pray you to take necessary action. This is the FIR, my lord. On the basis of this FIR, my lord, the case was registered under section 302 IPC and investigated. Police, my lord, during investigation, examined several witnesses, and in court, my lord, only 7 witnesses were examined. Out of those 7, my lord, PW7 is the IO, PW5 is the medical officer, and other 2 are independent witnesses, my lord. My lord, the informant is the mother of the deceased, my lord. She, during examination ship, my lord, she claimed that she had seen the accused Rajan Nayak killing her son Nasu Nayak from her house.
Let us see PW1
My lord, page
8.
8, my lord. Page 8, my lord. But my lord, with other witnesses said that the house of the informant is about half a kilometer away, and there are several houses in between the place of occurrence and the house of the complainant, my lord. So the learned trial court held in the judgment, my lord,
Let us see the depositions first. Let us see the depositions.
Depositions. I think he is little hard of hearing.
Oh,
my lord. The PW1, my lord. I am complainant of this case. I knew the accused person, Rajan Nayak, about 2 years ago. At about 5 p.m., I saw the accused person assaulting my son, Naku, with a dao in a paddy field, which is situated in front of my house. And as a result of the said assault, my son died on the spot. The accused person himself surrendered in the PS, and thereafter police came to the place of occurrence and took the dead body of my son for postmortem examination. I cannot see with my eyes. At the time of occurrence, my eyes were perfect. I filed FIR on the same day of occurrence. This is the ship, my lord. In the course, my lord, she has stated that houses of Hayab Praja, Joyram Nayak, Manglu Nayak, and Jugen Nayak are near my house. Praja's house is in front of my house. The place of occurrence is to the eastern side of my house. Houses of Rajan Nayak is situated to the eastern side of my house. After the house of Rajan Nayak, house of Suresh Nayak and Devan Nayak are there. From about 2 years, I could not see with my eyes. It is not a fact that the occurrence did not take place in the paddy field in front of my house. It is not a fact that I did not see occurrence myself. At the hospital, I was told that my son sustained injuries in his hand and neck. Police wrote the FIR and took my thumb impression in the FIR. It is not a fact that the accused person did not surrender in police station. The place of occurrence is about half a mile from my house. This is the evidence of PW1, my lord. Now PW2. PW2 is Puna Nayak, my lord. This evidence is that I know both the parties. About 2 years ago, at about 5 p.m., when I was pulling rickshaw, one villager informed me that the accused Rajan Nayak cut down my brother Naku Nayak with dao. Then I returned back home and took the dead body of my brother to Bihali Public Health Center with police for postmortem examination. This is the ship, my lord. The cross is the deceased Nakunayak is my younger brother. I do not know the name of the person who informed me about the occurrence. I do not know in which part of body of my brother sustained injury. When I returned back to my house, my auntie, the complainant, told me that the accused person assaulted Nakunayak from his backside with dowel. There are many houses between the places of occurrence and the house of the complainant. As such, the place of occurrence is not visible from the house of the complainant. This is the evidence of PW2. PW3, my lord, Srimati Saraswati Nayak. Her evidence is that she knows both the parties. About 2 years ago, at about 5 p.m., I heard the accused person cut down Nakunayak, the son of the complainant, at about 4:30 p.m. At that time, I was not present at home, and he died due to his injuries. Cross, my lord, that my house is situated at about 1 kilometer away from the house of the complainant. At the time of occurrence, I was not present in my house. I do not know how the occurrence took place. Only this much is the evidence. Now, my next one is the most important person, Sri Bhavan Mali. He has stated, my lord, I know the parties. About 2.5 years ago, at about 5 p.m., the accused person altercated with Nakunayak, deceased, and then accused person assaulted Nakunayak on his back with dowel. As a result, Nakunayak fell down on the ground and died on the spot. Seeing the same, myself and other 7 and 8 people went there, and I informed police about the occurrence. After some time, police came and took the dead body to Bihali police station for postmortem examination. During cross-examination, my lord, he stated that the occurrence took place on the western side of my nursery. Sheila Aron LP school is situated to the western side of my nursery. At the type of occurrence, 6-7 persons were working in my nursery. I do not remember the date of occurrence. Police recorded my statement. It is not a fact that I did not state before police that the accused hit deceased on his back with a dowel. I did not state before IO that the accused seized us with dowel when we tried to catch him. I do not know when the complainant lodged the FIR. I only saw injury on the backside of the deceased near neck. It is not a fact that I deposed falsely, my lord. This is the evidence of PW4. PW5, my lord, is the medical officer, and he found, my lord, cut injury over occipital region, my lord, over the ear. That is the known as occipital region, my lord. Of the size 5 centimeter to 1 centimeter into full thickness of the scalp. Number 2, multiple cut injuries over the front and right side of the neck involving the thyroid, cartilage, and larynx. These are the injuries, my lord. Now, the more in the detailed injuries, the injuries found on the body are antemortem in nature. Opinion: cause is death due to hemorrhage and shock as a result of the injuries, my lord. This is the evidence of doctor. Now, IO, my lord, he has stated many things, my lord. He stated that on 25/4/13, I was working as the in charge of Borgang outpost. That day, Shukurani Nayak lodged an Azahar on the basis of which I made GTNT number 330, dated 25/21, and forwarded the Azahar to Bihari police station for registration of a case. On the previous day, accused Rajan Nayak was brought to P on the basis of GTNT 36 370 dated 24/4/13. I made the GD entry after getting a phone call from a person accused Rajan Nayak of Borkathorite Pochabari killed a person. On reaching the place of occurrence, I found Rajan Nayak and apprehended him. Inquest was held on the dead body. I seized the dhow from the place of occurrence and examined the witnesses there itself. As it was evening, I sent the dead body for cross-examination on the next day. The name of the deceased is Nathu Nayak. On 26/13, I collected this post-mortem report. After the Azahar was lodged, I again went to the place of occurrence. I drew the sketch map of the place of occurrence. The next day, as a lot of people had gathered there on the date of occurrence, I recorded statement of the informant. After collecting post-mortem report, I concluded the investigation and submitted charge sheet against the accused Rajan Nayak for commission of offense under section 302 IPC. I seized the sharp dhow from the place of occurrence through scissor list 2. The exhibit 2 is the said scissor list and exhibit 1 is my signature. I have seen the seized dhow in the court today. Material exhibit 1 is the dhow which I have seized. Exhibit 3 is the charge sheet submitted by me, and exhibit 1 is my signature. This is his examination sheet. Then next, in procedure, at 5:10 p.m. on the date of occurrence, I received the information of the incident and reached the OP at 5:25 p.m. About 50% had gathered there. I recorded the statement of all the witnesses on the same day. At the same time, the place of occurrence is a field. I did not mention in the sketch map at what distance the residents are located from the place. Chintamani resides very close to the place, and I took his statement. Since Devan Nayak and Surya Nayak were not present, I could not record their statement. I record the statements of the people who live nearby. On the date of occurrence itself, I found the dhow lying near the dead body at the place of occurrence. None of the witnesses told me that seized dhow. I did not make a prayer to the court to record the confessional statement of the accused. I did not find blood-stained cloth and article at the place of occurrence. Witness Bhavan Mali did not tell me that the accused had assaulted the deceased on his back. I recorded the statement of informant next day at the place of occurrence. At that time, he himself came there. It is not a fact that I have not done the investigation properly. It is not a fact that the accused did not commit any incident with the seized dhow. It is not a fact that I have submitted a charge sheet on false grounds, my lord. My lord, now my argument is here. I would like to draw your lordship's attention to the seizure list, my lord.
Page.
Seizure list, my lord. At page 36 of the paper book, my lord. There he says, I, Sri Rajiv Guhai of Bargaon Outpost, PS Bihali, do hereby seize the below mentioned weapon from the possession of the accused Rajan Nayak in connection with the above mentioned GDE reference in presence of the below noted witnesses, my lord. My lord, this statement, was prepared just after the date of occurrence. But during examination in court, my lord, he himself went there that the dhow was lying near the dead body in the field and he had seized it from that place. These two differences, my lord, shows that the IO has not given the clear picture of the occurrence, my lord. Furthermore, my lord, he had received telephonic information, and he had made a GD entry. That GD entry has not been exhibited in this court to show that what actual information he had received as to the murder by accused or by any other person. That GD entry has not been exhibited, not shown. We do not pay it, my lord. Then, my lord, the learned trial court has discussed all the evidence and rightly held that mother of the deceased, that means PW1, is not a totally reliable witness. So the trial court discarded her evidence in toto, my lord. So evidence of PW1 goes. Then various evidence of PW2 and 3, my lord. They are not eyewitnesses and they have not seen the occurrence. They are not present. So they had only heard, but the persons whom they heard, those persons have not been examined in court. Therefore, their evidence also won't be counted, my lord. Now comes to evidence of number PW4, my lord. The PW4, my lord, he has stated that he saw the accused person altercating with the deceased. This evidence, and also he says that the accused Rajan Nayak, the appellant, my lord, had assaulted the deceased from the backside with a dagger. This is to be noted, my lord. The injury, according to him, the accused had assaulted the deceased from backside, and not from the front side. My lord, I am told by his relatives that there were differences. There were some differences between the deceased and this witness, my lord, because they are in the same village regarding grazing of sublet, and he had some enmity with this person. And he is a not reliable witness. How it is, my lord, I am going to show. Now, if your lordship believes him that he had seen the accused altercating and assaulting the deceased from behind, then injuries must be from on the backside. If he is struck with a dog from the backside, injuries cannot be on the front, right side, my lord, on the front side. Now, one more thing, my lord. Person may lie, but circumstances cannot lie. The doctor found injuries only on the front side, my lord.
Let's see the
And
post-mortem report again.
PW5.
No, the post-mortem report.
All the injuries are measured from the front side, my lord.
Page 32.
So if this, and another thing, my lord, this witness says that in his nursery, he saw the occurrence from his nursery, and there were about 6 or 7 other persons in his nursery, and they also came to the place of occurrence. But none of those witnesses have been examined by the prosecution or the IO, my lord. If this witness had seen the occurrence, certainly the other persons also would have certainly had seen the occurrence, but those persons have not been examined here. So, my lord, the entire case shows, entire evidence on record shows, my lord, that it is very doubtful whether the accused had himself caused the injury as a result of which the deceased died. So there is no reliable evidence on record, my lord. None can be believed here. Even IO has given a distorted picture, my lord, and he was over enthusiastic. He wrote that he had seized the dagger from the possession of the accused just to show that he may not be released on bail just after occurrence. But that is not the case. During the recording of evidence, he stated that he had seized it from the field. How can he say that in the seizure list that he had seized it from the possession of the accused? So there is, my lord, many things which create doubt whether the accused had committed the crime actually, my lord. And there is no evidence, reliable evidence on record, my lord, to convict the accused. So he may be, my lord, acquitted. And in the meantime, my lord, he was released on bail after about 5 years, only on this ground. But yes, unfortunately, he has not been released by jail, from jail because he did not find any bailer. But bail order is there, my lord. This is my
He's
submission,
still
my lord.
in jail.
Yes, he's inside. He's inside now.
Hmm?
Jail or Victor?
He's inside the jail.
Yes, my lord. Still is in jail because he has got 2 sons, my lord. Those 2 sons are with her sister. I contacted her sister, my lord. The sister says that no one is willing to take him on bail. He will be released after acquittal by the court, and then only he will come out. So she told me like this, my lord.
Yeah.
As far as the evidences are concerned, of course, PW1. I have checked the sketch map also. I don't see her house. Her house was not shown in the sketch map. PW2, I don't know why he addresses PW1 as auntie, because PW1 will be her mother, will be his mother. PW2's mother will be PW1, but he addressed her as auntie. Complainant told that accused as assaulted. But whatever it may be, PW2 had said that it will not be possible to see from the house of the complainant the place of occurrence. He had PW2, Lordship will see, in his cross-examination, he said, when I returned back to my home, he said that the deceased was his brother. My auntie, the complainant, told me that the accused person assaulted Nayak from backside with a dowel. And then he goes on to say, there are many houses between the place of occurrence and the house of complainant. As such, the place of occurrence will not be visible. That statement, whatever goes in favor of the accused, we will have to take it. So that statement goes in favor of the accused. So we can reach a conclusion that Sukumani PW1 had not seen. But we are left with evidence of PW4, Bhavan Mali. Bhavan Mali has in fact seen, he had said in his examination in chief, that is not demolished. As far as the contradiction is concerned, police have said that in the statement of the police personnel, page number 17, 5th lines from the bottom, 1, 2, 3, 4, 5, 6 line from the bottom of his cross-examination. He said, witness Bhavan Mali did not tell me that accused had assaulted the deceased on his back. This is, the contradiction is not regarding his witnessing the incident. Contradiction is Bhavan Mali did not tell me that the accused has assaulted the deceased on his back. I have checked the 161 statement of Bhavan Mali. It's there. Bhavan Mali has stated before the police that he, along with others, because Lordship will go to the sketch map once. Sketch map is at page, it's somewhere after charge sheet. 44, yes, 44. Apply. 44, Lordship will see there are 3 houses in front of the place of occurrence. 40, E, D, and C. E is the LP school. D is the house of Sintamani Nayak. He expired. Sintamani Nayak expired. So his statement could not be recorded. And C is Devan Nayak. And the PW4 name is Devan Mali. Bhavan Mali. So Devan Nayak, police said that he could not get this Devan Nayak, and so he could not examine him. And Chintamani is dead. So here what we see is there are 3 houses in front of the place of occurrence. And a place of PW1 is not shown in the sketch map. But Bhavan Mali, what he stated is that along with me, few other persons have also seen the occurrence. In fact, this Devan Mayak statement is there. We cannot take into account his 161 statement, but to reach the truth behind, not only Devan Mali, PW4, there were others also who had seen the occurrence. But they could not be found during the trial, and they were not examined. Lordship, Devan Mali's statement, I'll just read out, it is in English. A Bhavan Mali, PW4 statement before the police. My name and address is so-and-so, I'm a businessman. It is true that Rajan Nayak has killed Nathu Nayak today evening at about 5 p.m. with her dhow. At first, they quarreled with each other, and later Rajan Nayak killed Nathu Nayak. The whole incident happened in front of me. I thought that Sri Rajan Nayak will flee away from there, so I immediately informed the matter. What the contradiction is, he did not say that the accused has hit him on the back, but accused hitting the deceased is there in the statement of Bhavan Mali before the police. So contradiction as far as the hitting is concerned, there is no contradiction as such. This is from the backside what he meant. Because after seeing 161, it is clear Bhavan Mali had stated before the police about the incident. And he was the eyewitness. Along with that, few others were also there, but we cannot go into those unless we know that those persons were dead or something. Chintamani, in the charge sheet, it is said, Chintamani is dead. Lordship will see the charge sheet once. Charge sheet is at page 39. 39, the relevant part. Charge sheet starts from 38, the relevant part 39. Chintamani, it is said that he had died. On 7/8/2014. He died on 7/8/2014. And the trial was done on during February 2016. PW1 was examined in 15, but that was in October. And Chintamani died in 2014. Chintamani was also an eyewitness. His statement before the police shows that he was at the place of occurrence and he had seen it. I'll just read out the relevant parts. He heard hue and cry. And when he went to see what had happened, then he saw Rajan Nayak, Nathu Nayak were quarreling with each other. Both of them were in a drunken condition. After some time, Rajan Nayak had taken one dhow and injured Nathu Nayak on his neck and head. He has attacked 3 times with the dhow. Later, Nathu Nayak died on the spot. At that time, people gathered, but no one went there to save Nathu Nayak. But whatever it is, this statement, I don't know, long back, I got a judgment of the Supreme Court or High Court, I don't remember. If the person dies before the trial takes place, his 161 statement can be taken into account.
Where is the judgment?
That I don't know, but Lordship can see section 33 of the Evidence Act. Subject to correction, of course, section 33 of the Evidence Act. 33 or what? 33, yes. Relevancy. Relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated. Evidence given by a witness in a judicial proceeding. Of course, this is not a judicial proceeding. Or before any person authorized by law to take it. 161, the police is authorized to take statement. Is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of facts which it states when the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way of the adverse party, or if his presence cannot be obtained without an amount of delay or expense which under the circumstances of the case, the court considers unreasonable. In fact, I tried to find out whether the second sentence of the section, or before any person authorized by law to take it. So police personnel is authorized under 161 to take. So if any statement is given to him and that witness is dead or he cannot be found, then his statement becomes relevant in the subsequent judicial proceeding. Can be taken into account, section 33, but I'm not backed with any judgment today.
Can you get it?
That I'll try. That definitely I'll try. If I get it, I'll give it to your lordship. But apart from that, PW4, his statement stands.
You get the judgment first, then we'll consider.
And about medical, the discrepancy between medical and the eyewitness, that judgment also I'll bring. There the Supreme Court said, if there are discrepancies between medical and the eyewitness's account will be irrelevant. Unless the medical evidence is totally different. Now, if the eyewitness says that the person died by injuries with a machete, but the postmortem or the medical evidence says he died of gunshots. In those cases, medical evidence will be believed. But here is a case where injuries were caused by sharp cutting weapon. Backside, because postmortem said even on the right side, the injuries were there. So backside, maybe it fell on the right side, people saw it on the backside. So the discrepancy is not so grave that we will have to discard the medical oral evidence. That judgment also I'll bring.
How long will it take?
Tomorrow is the last day, I think. So
Not tomorrow.
they are on Tuesday, Wednesday,
After a week?
after a week, Wednesday.
Okay. Heard Mr. BC Das, legal aid counsel for the appellant. Also heard MS S. Jahan, Leonard, additional PP assigned. Release the matter again after 1 week.
Yes, it's love. One.
Sister will not keep it part of it. You never know what will happen.
Lot. I'll get it. Trying to get the judgment
Try
actually.
to get it,
Helpful in other cases also, but I'm not able to get it. I'll try.
especially the judgment of 161.
160.
All right.
2 and 3.
Lordship, may I?
Yes. Yeah, item 2.
Item number 2, Lordship. Lordship, I am the amicus curiae in this case for the appellant Anil Kujur, and he was convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000. In default of payment of fine, he was to undergo further rigorous imprisonment for a period of 3 months, Lordship. Lordship, the date of the incident is 14th of August, 2011.
Okay.
Lordship, the FIR
Date
is
of-
in page number 4, Lordship.
Date of incident,
The date of incident is, Lordship, 14th of August, 2011.
FIR.
FIR is at page number 4, Lordship. The informant is Manoj Borua. If I may read the Lordship, the FIR. At page number 4, Lordship. To the officer in charge, Rangapara Police Station, date 15/8/2011. Sir, I have the honor to state that around 9:30 p.m. on 14th of August 2011, one Marshal Kujur, resident of line number 11, Mainajuli division of our Dhalapadung Tea Estate, was assaulted and rendered grievously injured by his father, Sri Waris Kujur, and elder brother Sri Anil Kujur at his residence following a quarrel. Though I, along with members of the family and Sri Birsa Sawasi, Chowkidar of that line, took the injured to Rangapara Medical for treatment, the doctors there declared him dead after examining him. I therefore earnestly pray to you to investigate the matter and take necessary action in this regard and oblige. Yours faithfully, Manoj Borua. So, Lordship, this is the FIR Then Lordship, if I may come to the deposition.
Who's the informant?
The informant is Manoj Borua, and he was the welfare officer of the tea estate in like concerned tea estate, Lordship. Manoj Borua.
Yes,
Lordship, may I come to the deposition of witnesses?
yes.
There are 8 prosecution witnesses. The first one is Lordship. In page number 9, he is the doctor, Dr. Bijay Pal. May I read, Lordship? On 15/8/2011, I was at Kanaklata Civil Hospital, Tejpur as medical and health officer. And on that day, I performed post-mortem examination on the dead body of Marcel Kujur, 18 years male of Delapadung Tea Estate, Moinajuli Division, line number 15, in reference to Rangapara PS number 184 of 2011 under section 304 read with 34 of IPC, being identified by NK Nilambar Bhuya. On examination, I found as follows: a male dead body with dark complexion lying in supine position, eyes are open and mouth closed. After removal of all clot, blood seen in forehead and occipital region, abrasion seen in left chest and the abdomen, abrasion also seen in right hand arm and also right side of the neck of the back. Bruises are seen all over the back. There is no ligature mark seen around the neck. There is a hematoma in the occipital region with fracture in the occipital bone. Also, there is a fracture on cervical vertebra starting from 2nd to 5 number. Hemorrhage seen in the membrane. Hemorrhage also seen in the brain and spinal cord. Other organs are healthy. Injuries described above are antemortem in nature. Opinion. In my opinion, the cause of death is due to head injury as a result of blunt trauma over occipital region. Lordship may mark this blunt trauma over occipital region. The head injury is sufficient to cause the death of the deceased, Marcel Kujur. Exhibit 1 is my post-mortem report, and Exhibit 1(1) is my signature, and Exhibit 1(2) is the signature of Joint Director of Health Services, Sonitpur, Tejpur, which I know. Cross-examination. I did not mention in my post-mortem report that the hemorrhage seen in the membrane, brain, and spinal cord, whether it is internal or external, abrasion and laceration, as I have mentioned in my post-mortem report, are not grievous. Lordships may kindly mark this. Abrasion and laceration, as I have mentioned in my post-mortem report, are not grievous. Fracture in the cervical and occipital region are grievous in nature. Then Lordship may also mark the next sentence. Such type of injuries may be cured if the patient gets better treatment. The patient was brought before me from Rangapara PHC. Lordship, therefore, what emerges from the evidence, from the deposition of the medical officer is that.
One minute.
Interesting.
Was you?
But judgment was not.
Lordship, therefore, what.
Depositions were by Justice Nand. Deposition was taken.
Lordship, therefore, what.
Continue.
Yes,
You can continue. Yes.
whether we can continue, no problem with the deposition taken by me.
So, because in the earlier judgment that Ms. Bhuya had,
Yes, yes.
had
that is
mentioned,
why I
there
am
also
asking.
depositions were taken by your lordship.
Only
but
on.
But
Whether
judgment is
Lordship
not
had
by
said
Lordship.
appropriate bench. But then there was an order in the morning, lordship has ordered for appropriate bench. In that case also depositions were by Justice Nandi.
Yeah, the judgment is not by Lordship. On the
Yes.
only
So
the
it's up to
deposition.
you.
Lordship.
We believe in Lordship. We do not have any problem. We'll do it here. No problem.
John?
Because deposition, Lordship, deposition is what the witness is saying. No opinion is given by the
Yes.
court. It is
Yes.
just what the witness is saying, the court is
Yes.
recording. So we have full faith, Lordship. We'll do it here.
Proceed.
Lordship, therefore, what emerges from the deposition of the medical officer is that the aberrations and the lacerations that is mentioned in the post-mortem report all are not grievous in nature, and only the injury that was on the head, that injury was grievous in nature. And further, he also mentions in his cross-examination that these type of injuries which was caused to the accused person, if the accused gets better treatment, there is possibility that the accused might be cured, Lordship. Now, Lordship, we come to the deposition of PW2. That is Manoj Borua. He is the informant, Lordship. That is at page number 11, Lordship. May I read, Lordship?
Yes.
I know both the accused persons present in the court today. I am the informant in this case. The occurrence took place on 14/8/2011. On that day, at about 9:30 p.m., pharmacist of our tea estate, Muzammil Sikdar, informed me over phone in the line number 15, one man has been murdered. Lordships may kindly mark this, that it was from Muzammil Sikdar that the informant came to know about the incident. I informed police of Rangapara police station and I went to the place of occurrence, and also police came to the spot. When I reached the place of occurrence, I found that the dead body of Marcel Kuzur brought from inside the house. On being asked, I came to know that Marcel Kuzur was killed by both the accused persons. Marcel Kuzur was taken to Rangapara hospital and doctors declared him dead. After that, I lodged the Azahar. Exhibit 2 is the Azahar and Exhibit 2(1) is my signature. I wrote the Azahar Exhibit 2 myself. Photographs of the deceased was taken and police seized the said photographs and prepared the Caesar list, and I put my signatures in the said Caesar list. Exhibit 3 is the Caesar list and Exhibit 3(1) is my signature. Then cross-examination. When Muzammil Sikdar informed me over telephone about the incident, I was in my tea estate quarter. I do not know from where Muzammil Sikdar informed me over phone. Over phone, Muzammil Sikdar informed me that an incident took place in line number 11 of Moinajuli division. On receipt of information from Muzammil Sikdar, I immediately informed the police matter to the police of Rangapara PS. The time was about 10 to 10:30 p.m. Police came to the spot at about 12 at night. On the same night, the deceased was taken to Rangapara PHC with the help of police. On the next day morning, I went to the police station and lodged an Azahar. On the day of occurrence, I was examined by police, and police also examined other witnesses present at the spot. The deceased was under the observation of doctor of Rangapara PHC. After half an hour, doctors declared Marshal Kujur is dead. No any chokidar of the tea estate informed me about the incident. I did not mention in the FIR that I came to know about the incident from Muzammil Sikdar. It is not a fact that I did not state before police that I came to know about the incident from Muzammil Sikdar. Then his re-examination by prosecution. Police also seized one bamboo stick from the house of the accused. Police prepared the Caesar list and I put my signature in the Caesar list. Exhibit 4 is the Caesar list and Exhibit 4(1) is my signature. Material Exhibit 1 is the bamboo stick, which I have seen in the court today. Then his re-cross-examination by defense. I do not know where from the police brought the bamboo stick, which was seized later on. So Lordship may mark this, that the material exhibit was seized later on. I have seen the bamboo stick when the Caesar list was prepared by the police. This type of stick is available in the house of every person who have domestic animals. I do not know who is the owner of the alleged bamboo stick. I do not have any knowledge in respect of taking photographs and video cassettes of the deceased. I only put my signatures on the Caesar list. Therefore, Lordship, what emerges from the evidence of the informant is that he did not witness the murder himself. He was not an eyewitness. He was informed by somebody else. But that person who informed him, he was not examined by the police. And he also did not mention in the Azahar that it was he who have witnessed the incident. So he was merely like, he heard about the incident from somebody else. He was not the eyewitness. And on his re-examination, he told that the Caesar item, that is the bamboo list, was seized by the police later on. Then, Lordship, we come to the deposition of PW3 in page number 14. This person, Birsa Sawasi, he is one of the neighbors of the accused persons and the deceased. I know accused Anil Kujur and Waris Kujur. They are from our village. I knew deceased Marshal Kujur. The incident took place in the evening of 14th August 2011. I saw lots of people gathering in the house of Marshal Kujur. Since someone called me, I went to Marshal Kujur's house. I saw Marshal Kujur lying dead on the bed. I don't know who killed Marshal Kujur. Later on, when police seized the lathi, I put my signature in the seizure list. Exhibit 4.2 is my signature in the seizure list. Police took photograph of the dead body. Police seized a compact disc. I put my signature in the seizure list. Exhibit 3.2 is my signature in the seizure list. At this stage, the witness is declared hostile by the prosecution. As a witness declined to support the statement allegedly made before the IO, learned APP has prayed to the court to allow the witness to declare hostile, seeking permission to cross-examine him on the material points for eliciting the truth. I have perused the statement of the witnesses as recorded by the IO, and it is found that the witness has prevaricated the statements made by him to the IO. Hence, learned APP is permitted to cross-examine the witness. Then in the cross by prosecution, he told that it is not a fact that in my statement to police, I had stated in such words. Immediately, I went to the house and saw that Marshal Kujur was lying on the ground and blood was coming out through his mouth and nose. Marshal's elder brother, Anil Kujur, confessed to me that he had killed Marshal. Then the first question by prosecution, did you not state as above to the IO? Answer, no, I did not. Question number 2, if you did not state the above thing to the IO, then why the IO cited your name and wrote that you stated it to him? Answer, I don't know. The two accused persons reside in line number 15, the line in which we reside. We work together. I know them since long back. The two accused persons have been residing in the same village subsequent to the incident, and I happen to see them often. It is not a fact that since I know the accused persons from long back and since they are my fellow villagers, I have falsely stated that Anil Kujur did not confess to me that he has killed Marshal, despite Anil Kujur confessed the same to me. It is not a fact that in order to save the two other accused, I have adduced false evidence. Defense. Cross by defense. Police obtained my signature in the seizure list at the police station. Police did not seize any article in my presence. Lordship may mark this. Police did not seize any article in my presence. I do not know how Marshal Kujur died. The two accused persons did not make any confession before me. Today, I have deposed the truth in the court. I did not state to police the way the public prosecutor has mentioned. I don't know what the police has recorded. So, Lordship, now this person has been declared a hostile witness and he retracted. Supposedly retracted from whatever he told before the IO. So he denied everything. He even denied that he was interrogated by the police, and he denied the entire incident. And he also told that the police did not seize any article in his presence. Then, Lordship, the deposition of PW4. May I read, Lordship? PW4 is Anil Karmakar. He is also one of the neighbors of the accused person. I know accused Waris Kujur and Anil Kujur. The incident took place about 5 months back. On the day of incidents, I was at home, having heard a hue and cry in the night. That day, while I am alone, I came out of the house to the road near the accused duo's house and learned that accused Waris Kujur's son, Marshal Kujur, had died. The dead body of Marshal Kujur was brought out of the accused Waris Kujur's house. I don't know how Waris Kujur died. Police did not question me in connection with the occurrence. He was also declared hostile by the prosecution. Then, Lordship, after he was declared hostile, he was crossed by the prosecution. Then in cross, he told, it is not a fact that in my statement made to police, I stated in such words, in the evening of 14/8/2011, I came to know from the people living in our line that Marshal Kujur was severely assaulted by his father, Waris Kujur, and elder brother, Anil Kujur, and that they killed him by assaulting him by means of a wooden post. After learning about the incident, I went to Marshal Kujur's house, found Marshal Kujur lying on the ground and blood all over. I also saw the bloodstained piece of wood lying nearby. My house is about 200 meters away from that of the accused persons. In between, there are quarters of about 10 families. I know the accused person since before. Waris Kujur's wife, Anjali Kujur, has accompanied me to the court today. Then next page. It is not a fact that since the accused persons are my acquaintances, I have concealed the truth despite knowing the truth for the sake of the accused persons. Then in cross by defense, the two accused persons lived in separate houses. Deceased Marshal used to live separately in between. The house of accused Anil is about half a furlong away from that of the accused Waris. The house of deceased Marshal is also about half a furlong away from the house of the accused. It was a dark night in the night of occurrence and it was raining. When I reached the place of occurrence, I saw a lot of people gathering near the house of the accused. Seeing Marshal's dead body at the courtyard of Waris' house, I left therefrom. Marshal was a heavy drinker. He often quarreled with the inhabitant of his line. That is why a lot of people disliked him. I don't remember the names of the persons whose houses are situated near that of the accused. I don't know how Marshal had died or who had killed him. Police never questioned me in connection with the incident. Whatever police has recorded is not my version. I have not deposed the false for their sake. Again, Lordship, this person also was declared hostile and he said that he has not seen the entire incident. He was not even interrogated by the police. Then we have the deposition of PW5. Her name is Anjali Kujur and she is the mother of the accused person. Mother of this person, the appellant on whose behalf I am arguing, and the wife of the next appellant, Waris Kujur, and mother of the deceased, yes. Accused Waris Kujur is my husband, and the other accused is my son. Deceased Marshal Kujur was also my son. Around 9 p.m. on 14th August 2011, deceased Marshal Kujur came home after getting drunk. At that time, I was at home having my dinner. After having my meal, I came out and I saw that Marshal lying dead. A big wooden post was seen lying near his body. I don't know how Marshal had died. Police did not question me in connection with the incident. At this stage, the witness is declared hostile by the prosecution. And then again, Lordship, he was crossed by the prosecution. And in cross, she told that it is not a fact that police questioned me in connection with the incident. And I made my statement to police in such terms. In the evening of 14/8/2011, a quarrel took place in connection with the cows eating paddy saplings. Everybody was under intoxication at that time. At first, my elder son, Anil Kujur, fought with him. Later on, father, Waris Kujur, assaulted him with a lathi and then hit him on the head with a piece of wood lying nearby. Immediately, blood started oozing out from Marshal's mouth and chest and he fell down. After a short while, he was taken to Rangapara Hospital and doctors declared him dead. Anil Kujur, Marshal Kujur, and we live separately, but in the same compound. In our courtyard, there are granary, timbers, etc. There is a road in front of our house. There are houses of other people on the other side of the road. Our courtyard is a big one. On both the sides of the courtyard, there are houses of other people at some distance. We have cultivation and cattle too. On the day of occurrence, the cows grazed our paddy saplings near the day hours. At the time of occurrence, my husband, deceased Marshal, his wife and I were present at home. On the day of occurrence, I too consumed liquor after coming home from transplanting paddy saplings. All other members of the family had also consumed liquor. It is not a fact that initially the quarrel ensued over deceased Marshal's cows grazing the paddy saplings of Anil. It is not a fact that the two accused persons assaulted my son Marshal with a piece of wood, that at that time I was under intoxication and that Marshal's wife Anjali was also present there. It is not a fact that since the two accused persons assaulted Marshal, he bled from his nose and mouth and sustained injury on his chest. It is not a fact that despite witnessing the incident, I have adduced false evidence in favor of the accused persons since they are my husband and son. It is not a fact that I have falsely stated that the wooden post had fallen on Marshal's chest. Then next page, the cross by defense. Accused Anil has been living separately since 2 years prior to the incident. He lived at some distance from us near the bank of the river. In between my house and that of Anil, there are houses of other persons and a playground. My husband and I live in the quarter provided by the garden. Lordships may mark this, the first line, accused Anil has been living separately since 2 years prior to the incidents. Lordship may, for a second, Lordship may turn to the prior page, Lordship. There also it is written that Anil Kujur, Marshall Kujur, and we live separately. Lordships may mark this.
The same compound.
In the same compound, but they live separately. Lordship, the next page. Accused Anil had been living separately since 2 years prior to the incident. He lived at some distance from us near the bank of the river. Lordship may mark this also. In between my house and that of Anil, there are houses of other persons and a playground. My husband and I live in the quarter provided by the Garden Authority. We constructed a house on our land and gave it to Marshall. Except those 2 houses, there are no other houses in our compound. Deceased Marshall used to drink alcohol and create nuisance. On the day of occurrence also, Marshall came home drunk and quarreled with some boys who were playing ball at our courtyard. Initially, we did not come to our home since Marshall used to create nuisance daily after getting drunk. At that time, Marshall's wife Anjali was serving us meal. Having heard hue and cry, I came out first, followed by my husband and daughter-in-law Anjali. After coming out, I saw Anil lying holding a post. He was dead. I informed Anil. Later says, having heard the halla, Anil himself came to our house. Then lots of neighbors came there. On the day of occurrence, no quarrel took place in connection with the cattle eating paddy saplings. Though we consumed liquor, we did not get befuddled. Accused Waris Kujur cannot drink alcohol. The 2 accused persons had not assaulted my son Marcel. Police did not record my statement. I don't know what was written by the police. Whatever I have deposed today is true. Deceased Marshall was a heavy drinker and had enmity with the inhabitants of the line. My husband Waris and son Anil did not assault Marshall. I don't know how my son Marshall died. Lordship, again, the mother of the accused was declared hostile, and not only was she declared hostile, she even told that she was not interrogated by the police, and she also gave a completely different story than what was supposedly narrated by her before the police. So she gave a complete different story, narrated a completely different story about how the incident took place, and she was declared hostile. Now we have the deposition, Lordship, of, this is not that important, the videographer, PW6, Lordship, Utpal Totta. Lordship, should I read this?
It's not.
It's not that important of the videographer. Lordship, he just told that he made a videography of the entire incident. Then, Lordship, we have the deposition of PW7. This is the IO, Lordship. PW7, Rishikesh Dwara, he was the IO. On 15/8/2011, I had been working as sub-inspector at Rangapara police station. That day, the officer in charge received an ezahar from one Manoj Borwa, the welfare officer of Dhulapadung Tea Estate, and he entrusted me with the investigation. Accordingly, I went to the place of occurrence. After going to the place of occurrence, I drew a sketch map. I found both the accused persons at their home. Their house is situated in line number 15. I brought them as well as the witnesses from the neighborhood to the police station for questioning. I went to the house of deceased Marshall Kujur, but he was already taken to hospital. I went to hospital. The doctors declared him dead, but I could not hold the inquest since it was night. On the following day, I held the inquest on the dead body at the hospital. Exhibit 5 is the inquest report, whereas Exhibit 5.1 is my signature. Thereafter, I sent the dead body for post-mortem examination. I prepared a dead body challan. Exhibit 6 is a dead body challan, whereas Exhibit 6.1 is my signature. I examined the witness at the police station and recorded their statements. I got the post-mortem examination of the dead body done by the doctor and collected the post-mortem examination report. I drew the sketch map of the place of occurrence. Exhibit 7 is the sketch map and 7.1 is my signature. I again went to the place of occurrence. accused Waris Kuzur said that he has killed the deceased by assaulting him with a lathi. And since he said that he would show the lathi, I went to the deceased house, and on being shown by the accused, I seized the said lathi. Exhibit 1 is the seized scissor list, wherein Exhibit 4.3 is my signature. I recorded the statement of the accused and got the videography in connection with leading to discovery done and saved the same in a compact disc. Exhibit 3 is the scissor list, whereas 3.4 is my signature. I brought deceased wife Anjali Kujur to the court for recording of her statement and got her statement recorded in the court under Section 164 CRPC. I have recognized the signature of Ranjit Gogoi, OC of Rangapara Police Station in the Azahar. Exhibit 2 is the Azahar, whereas Exhibit 2.2 is the signature of OC Ranjit Gogoi. I arrested Waris Kujur and Anil Kujur and forwarded them to the court. Having found materials against the accused persons, I submitted charge sheet against them for the offense under Section 302 of IPC after concluding the investigation. Exhibit 8 is the charge sheet, whereas 8.1 is my signature. I recorded the statement of witness Birsa Sawasi. He stated to me that on being informed by some inhabitants of that line, he went to Marshal Kujur's house and saw Marshal Kujur lying on the ground and blood oozing out from his nose and mouth. He said that Marshal Kujur's elder brother, Anil Kujur, confessed to him of killing Marshal. Birsa told me about his giving the information to the welfare officer. PW4, Anil Karmakar stated to me that in the evening of 14/8/2011, he came to know from the people of line that Marshal Kujur was severely assaulted by his father Waris Kujur and Anil Kujur, and that they had killed him by assaulting him with a wooden post. He also said that after knowing about the occurrence, he went to Marshal Kujur's house and saw Marshal Kujur lying on the ground with blood around him and a bloodstained piece of wood lying nearby. PW5, Anjali Kujur stated to me that in the evening of 14/8/2011, her younger son Marshal Kujur had an altercation with the husband Waris Kujur and elder son Anil Kujur regarding their cows eating paddy saplings in the field, that at the time all were under intoxication, that at first her elder son Anil Kujur assaulted him, and then his father Waris Kujur assaulted him with a lathi, and after that he hit on the head with the piece of wood lying nearby, that immediately it started bleeding from Marshal's mouth and chest, and that he fell down on the ground instantly. Material Exhibit 1 is the bamboo stick seized. I have seen and recognized in the court. Since the piece of wood was too big in size, it could not be seized. Material Exhibit 2 is the compact disc regarding leading on discovery. Exhibit 3 says the list does not bear the name, any mention with regard by what time and on which date and in whose presence Material Exhibit 2 was seized. I did not mention in Exhibit 3 that Waris Kujur led me and showed the material. I arrested the accused on 15/8/2011. On the same day, I forwarded the accused to the court. I did not get the Exhibit 3 through which the compact disc containing the videography was seized and marked as seen by the magistrate. I know the difference between a bamboo and a cane. I have mentioned in the seizure list that I have seized a cane stick. Though I obtained thumb impression of Waris Kujur in the Material Exhibit 1, there is no endorsement of the person who obtained it. I did not send the Material Exhibit to FSL. I did not submit any report regarding my inability to seize the piece of wood. The lathi was shown to me only after the arrest of Waris Kujur. There are many people in the house of the accused when I brought him. I did not record the statement of Waris Kujur. The endorsement of the person who obtained the thumb impression of Waris Kujur in the seizure list is not available in it. I have not written Exhibit 3, the seizure list, that the accused person put his thumb impression on it only after the contents were read over to him. The videography was done in the house of the accused, but the compact disc of the same was shown to be seized at the police station. In Exhibit 7, I have not shown the houses of the people nearby the houses of the accused. It is not a fact that Anjali Kujur made her statement the way we taught her. I did not receive any certificate with regard to Material Exhibit 2 from the person who made it. It is not a fact that I did not seize lathi on being shown by Waris Kujur. It is not a fact that Anil Karmakar, Birsa Sawasi and Anjali Kujur did not state it to me in the manner I have written down. It is not a fact that I have submitted charge sheet against the accused persons for offense under Section 304 at with 34 on mere suspicion. So Lordship, this person, the IO, he actually confirmed that the retracted statement of the other witnesses, of the hostile witnesses, whatever was retracted by them, the IO said that in fact those statements were made by those persons. However, he has not, there were supposedly two material exhibit. The piece of wood was not seized by him, and also
Just a
the
minute. You want to take your medicine? Proceed.
yeah, and also the material exhibit were not sent to the FSL Lordship. Then Lordship, we come to the statement of the same person, IO, his further examination. That is in page number 32. On oath, I was the investigating officer of this case. On 15/8/11, when I was working as the sub-inspector of police, Rangapara PS, I had examined witness, namely Anil Kujur, wife of late Marshal Kujur, in connection with Rangapara police case number 184 of 2011. During statement, said witness has stated before me that on 14/8/11 at about 6 p.m. in the evening, while my husband Marshal Kujur was taking his meal, my father-in-law Waris Kujur and my brother-in-law Anil Kujur had made altercation with my husband. I, along with my mother-in-law Anjali Kujur, were present nearby. She had also stated before me that the accused persons had attacked my husband by lathi and piece, causing injury on the head and chest of my husband, and blood oozing out from the mouth and nose of my husband, resulting in the death on the spot. Cross by defense. It is not a fact that witness PW8 Anil Kujur has not, Anjali Kujur has not stated before me as the way I have stated today before the court in my examination in chief. It is not a fact that the version which I have stated before the court today was not the version of witness PW8 Anjali Kujur. Again, he confirmed also the retracted statements of Anjali Kujur, who was the wife of the deceased person. Then, Lordship, we come to the deposition of PW8, that is Anjali Kujur.
The wife of the deceased.
This is the wife. I know the accused person. Accused Waris Kujur is my father-in-law, and accused Anil Kujur is my brother-in-law. She is the wife of the deceased lord. Waris, deceased Marshal Kujur was my husband. The occurrence about 6 years ago, I was sleeping in my house and hearing halla. I came out and found my husband lying on the courtyard. He was in a drunken state and he died in the courtyard. I became senseless. I have also not noticed any injury mark on the body of my deceased husband. I do not know as to how my husband died. My statement was recorded by magistrate under section 164 CRPC. Exhibit 7 is the said statement wherein I put my thumb impression. Police has not recorded my statement. At this stage, the witness is declared hostile. As per submissions of the learned additional PP, it is not a fact that I have stated before the police that on 14/8/11 at about 6 p.m. in the evening, while my husband Marshal Kujur was taking his meal, my father-in-law Waris Kujur and my brother-in-law Anil Kujur had made altercation with my husband. I, along with my mother-in-law Anjali Kujur, were present nearby. I have not stated before police that the accused persons has attacked my husband with lathi and wooden piece, causing injury on the head and chest of the husband and blood oozing out from the mouth and nose of the husband, resulting in death on the spot. It is not a fact that I have stated before police that the accused persons are the murderer of my husband. It is not a fact that in spite of being an eyewitness, I have deposed falsely today to save the accused persons. Cross by defense, I have not seen as to how my husband died. I do not know as to who had murdered my husband. I have not stated before police as put to me by the prosecution today. During cross-examination by the prosecution on earlier occasion, I made statement before the magistrate as tutored by police. Today, I have stated the true facts. So she also retracted completely and she was declared hostile. So Lordship, now, if we go through the evidence, what emerges from the evidence is that the two eyewitness, supposedly eyewitness.
Where's the 164 statement?
164 statement is not annexed in the paper book. It's not, it is annexed. In maybe it is given in yours.
No, page 70, Lordship, page 70.
Page 70, it's given.
Page 70 and 71. 70.
Okay. 70, isn't it? What is- May I read, Lordship?
Yes.
Form of recording deposition statement of witness Srimati Anjali Kujur has been recorded under 164 CRPC with reference to Rangapur PS case number 184/11 under section 304 read with 34. The deposition of witness Anjali Kujur. My name is Anjali Kujur. I am about 18-19 years old. I got married to Marshall some 6 months back around 6 p.m. on 14/8/2011, while my husband was having dinner in the courtyard, my father-in-law Waris Kujur and brother-in-law, here husband's elder brother, Anil Kujur, entered into an altercation with my husband regarding cows eating paddy saplings. I was standing nearby. My mother-in-law was, her name is also Anjali Kujur. So both of their names are Anjali Kujur, was also standing nearby, but she had under the influence of alcohol. Then my father-in-law and mother and brother-in-law, here husband's elder brother, assaulted my husband on the head and chest severely with a wooden post lying nearby, as a result of which my husband fell down instantaneously. My husband was bleeding from his mouth, nose, and chest, and my husband died on the spot before my eyes. Later on, our neighbors, Biru Karmakar, informed the police, and police came. Though my husband was taken to the hospital, he could not be saved. That's all I have to say. But in her evidence, Lordship, she told us she was being tutored by the police regarding her 164 statement. So, Lordship, now what emerges from the evidence is that we have two eyewitnesses. Supposedly, we have two eyewitnesses, and that is the PW5, Anjali Kujur, who is the wife of the accused, and PW8, who is the wife of the deceased person. However, both of them were declared hostile by the prosecution, and they denied making any such statement before the police. In fact, PW5, that is the wife of the accused Waris Kujur, gave a completely different version, and also PW8 also in her evidence gave a completely different version of what happened. So apart from the informant, all the witnesses were declared hostile in this case. However, the witness, the informant was not the eyewitness in the case. He was, whatever he has written was merely hearsay, as accepted by himself only. Now, Lordship, therefore, this case is entirely based on circumstantial evidence. Now, it's a settled law that in cases of circumstantial evidence, the circumstances from which the conclusion of guilt of the accused can be drawn should be fully proved. And such circumstances should be conclusive. There should be only one conclusion that points towards the guilt of the accused person, and there should be no other conclusion regarding this. And this is a settled law. Therefore, now it is required to be seen whether the prosecution has succeeded in proving the case beyond reasonable doubt. And from the evidence, from the depositions, whatever I have stated before, Lordships, it is clear that none of the witnesses supported the case of the prosecution. They retracted from their prior statements, and some of them, even the eyewitnesses, in fact, gave a completely different story, narrated a different story of how the incident supposedly took place. Then, Lordship, the learned trial court cited one case for convicting the accused persons, Lordship. If I may take Lordship to the paper book, page number 53, Lordship. Lordship, were found in Anjar Hussain. May I read, Lordship?
Yeah.
In Anjar Hussain Mohammed versus State of Assam, reported in 2016 for GLT, the Honorable Guwahati High Court observed, the homicidal death of Jeleka Khatun and recovery of the dead body from the house of the appellant has not been disputed. It is also not in dispute that at the time of the occurrence, none other than the appellant and his mother were in possession of the house. There is, however, absolutely no explanation on the part of the appellant or his mother as to how the incident occurred in the house under their possession. In the case of Trimukhi Maruti Kirkan versus the state of Maharashtra, the Supreme Court has observed that when an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution, but the nature and amount of evidence to be led by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. The burden would be of a comparatively lighter character. In view of Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give cogent explanation as to how the crime was committed. So, Lordship, the trial court convicted the accused basing on this analogy only, that because the accused persons were inside the house along with the other people, so the appellant, so the accused persons were supposed to give an explanation as to how the incident took place, and the accused persons did not do in this case. Lordship, but this, in my humble opinion, this analogy is not correct, because this analogy would have been the case had the accused persons, like the dead body, were recovered from the inside the house of the accused persons, but it was not that in the present case. As have been deposed by the witnesses, some of them even say that the accused person has admitted fact that both of the accused persons lived separately. So they were not in one house. So they were not the inmates of the same house. And secondly, Lordship, nobody told that there is no clear statement regarding the fact that the dead body of the accused, the dead body of the deceased person was found inside the house of the accused person. Therefore, in my humble opinion, to convict the person based on this analogy would not be correct. Therefore, in my humble opinion, the accused persons are entitled to acquittal. Lordship, and I have an alternative prayer to make, Lordship. Lordship, is apparent from the judgment that the accused persons were convicted under Section 302. So, Lordship, if I have failed to convince Lordship regarding the fact that the accused persons are not entitled to acquittal, that in my humble opinion, Lordship, this is at best a case which will be covered by Section 304, Part 2 of the IPC, Lordship. Regarding this, Lordship, I want to place two small case laws, Lordship. Citation. Citation. Lordship, the citation is 2009 SCC 1. 2009 SCC 1, Camilo Vaj versus State of Goa. May I read the relevant portions, Lordship?
Yes.
Lordship, paragraph number 1. Sole appellant is aggrieved by the judgment dated this one of the Bombay High Court at Goa, upholding his conviction for the offense under Section 302 of the IPC and sentence of life imprisonment awarded to him by the District and Sessions Judge South Goa at Margao. Lordship, then paragraph number 9 in page number 2, Lordship.
Yes.
There cannot be any dispute about the incident having taken place where three brothers received injuries resulting in the death of one of them. The question which has now been seriously contended before us is could in these circumstances the appellant be held guilty of an offense under section 302 IPC. Then paragraph number 10, the instant incident is the fallout of quarrel between the rival gangs of Karebad and Falconda. Then Lordship, paragraph number 13 in page number 4. I have taken the liberty to mark it, Lordship. Lordship has found these boys. I have marked the sentence, Lordship.
Oh.
Lordship, have got that? These boys of Fareband who came to the house of the three brothers were armed with dandas, bottles, and cycle chains. The purpose apparently was to beat up the brother by giving them sound beatings, but certainly not with the intention to kill any of them. Lordship may mark this, not with the intention to kill any of them. In fact, Irinu, in his first information report, stated that there was no enmity between them. In these circumstances, can it be said that the appellant has committed the offense of murder because he hit Simon on the head, a vital part of the body, with such a force with danda in his head that Simon fell unconscious and later succumbed to his injury? To us, it appears at the most, it can be said that the act of the appellant in hitting Simon was done with the knowledge that it was likely to cause death, but without any intention to cause death or to cause any bodily injury as is likely to cause death. The case of the appellant would therefore clearly fall under section 304 part 2 IPC. Courts below did not apply their mind to this aspect of the matter in proper perspective, and they were rather swayed by the fact that on account of the danda blow by the appellant, Simon died an unnatural death. There is no material in record which show that appellant was bent upon killing Simon and eventually death came upon as a result. This is merely a surmise of the High Court. Section 304 is as under. The next page, Lordship. Punishment for culpable homicide not amounting to murder. Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine if the act by which the death is caused is done with the intention of causing death, or by causing such bodily injury as is likely to cause death, or with the imprisonment of either description for a term which may extend to 10 years, or with fine, and with both if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death or to cause such bodily injury as is likely to cause death. This section is in two parts. If analyzed, the section provides us two kinds of punishment. If the act by which death is caused is done with the intention of causing death or causing such bodily injury as is likely to cause death, here important ingredient is the intention. Then secondly, if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death or such bodily injury as is likely to cause death, when a person hits another with a danda on a vital part of the body with such a force that the person hits meets his death, knowledge has to be imputed to the accused. In that situation, case will fall in part 2 of the section 304 IPC. As in the present case, we are also not oblivious to the fact that the other 4 accused were similarly convicted with the aid of section 149 IPC, having dealt only with regard to 326 IPC. We therefore hold the accused to be guilty for an offense under section 304 part 2 IPC. His conviction is therefore set aside. So, Lordship, our case is very much similar to this case, Lordship. So it is a case of a family dispute where apparently, even if a case is made out, my first prayer is for acquittal, then Lordship in the alternative, if at best they can be like punished, then it can be said that there was an instant quarrel which took place without any premeditation, without intention, and there was no prior enmity. It was on a, maybe on a small like pretext of some paddy saplings that the fight took place, and in the heat of the moment, maybe there's some fight arose and they hit with the stick. And even in the doctor's report, which I have read, I have clearly mentioned that the doctors say that only one injury that was on the head was grievous, and the other injuries and the lacerations were not grievous in nature. So, Lordship, my alternative prayer is that, having regard to the relationship of the parties, that is unfortunate incident occurred as a result of sudden quarrel, and also considering the fact that there is no intention on the part of the appellant, at best accused persons may be convicted under 304 part 2, Lordship. This is my humble prayer, Lordship. I have another case law, Lordship. May just mention it. I have a copy. It is regarding the same thing, Lordship. There's a citation I can give, Lordship.
You don't have copies?
I have copies. There's a small one. If Lordship permit, I can read also the relevant lines, 2 paragraphs.
Give us the citation. Citation?
The citation is 1993 Supply 2 SCC 650. 1993 Supply 2 SCC 650. Ramautar versus State of Madhya Pradesh. May I read, Lordship?
Yes.
Paragraph 2. The learned additional session just convicted all the accused persons under 302, read with 149 IPC. Then, Lordship, paragraph number 5. The learned counsel has contended that there was no intention of Ramautar to kill the deceased Vimla Bai, and even if it is held that the injuries were caused by Ramautar by hitting the deceased Vimla Bai on head and ribs by lathi, it cannot be reasonably held that there was any clear intention to kill Vimla Bai. In the aforesaid circumstances, it will only be fair and consonant to justice that the appellant should be convicted for causing grievous injury. This was, the prayer was for a still lesser offense, only for grievous heart, Lordship. Then, Lordship, paragraph number 7. After giving our anxious consideration to the respective contentions of the learned counsels for the parties and considering the fact and circumstances of the case, it appears to us that Ramautar himself sustained injuries in the hand of the son and Kamal Singh. Although in the FIR it was specifically mentioned that Ashok, the brother of Vijay, has caused injuries on the person by way of self-defense, the prosecution witnesses attempted to deny such fact of assault caused on the person, but multiple injuries, including a fractured wound, was notable by the doctors examined in hospital. We are inclined to hold that Vijay had caused injuries to Ramautar, but simply because the injuries were caused on the person of Ramautar, it cannot be held that he had, by way of self-defense, to cause serious injuries on the deceased Vimla Bai, who was unarmed and did not assault anyone. It appears to us that it was not reasonably expected that a wife of Kamal Singh, deceased Vimla Bai, would come out of the house dead of the night. As a matter of fact, she did not come out of the house initially, but hearing the cries of her son, she has come out. It is only unfortunate that Ramautar, after being assaulted by Vijay, had stuck to the lathi on the vital part of the body and deceased, causing serious injuries on the head and fracturing the ribs. It may be noted that expecting Prem Chand, none of the accused persons, including the appellant, had any sharp cutting weapon, and the appellant Ramautar had only a lathi in his hand. We are therefore inclined to hold that the injuries caused by Ramautar were not inflicted with the sole intention of causing death of the deceased, but when a lathi blow was dealt with the force on the head of the deceased, it may be contended that the accused should be aware that such an injury was likely to cause death. We are therefore of the view that conviction under 302 IPC is not justified, and this conviction and sentence of the appellant by the High Court are set aside. In our view, the appellants are to be punished under section 3041 IPC. Accordingly, we convict the appellant under 304 part 2 and sentence him to suffer rigorous imprisonment for a period of 8 years. Lordship, again, this is a similar case. Here only one blow was given by our lathi, Lordship. And in our case also, Lordship, they were unarmed person. And the material exhibit, the instrument by which death was caused in a village household, these are the common items. So in the fit of an anger, in the fit of quarrel, he just picked up whatever he found and just hit it. So it was in the hit of a moment, sudden quarrel was there, and there was absolutely no intention of the accused persons to cause that. Even if, for the sake of argument, we accept that this incident did take place as projected by the prosecution. Lordship, this is my humble submission before Lordship.
May it please your Lordship. Lordship, herein from the very beginning, from the FIR itself, we find that a quarrel is mentioned. In the FIR itself, at line 4, Lordship, it is said that following a quarrel, there was basically a quarrel between the parties. Then, Lordship, the witnesses, most of them are hostile witnesses, but I'm not submitting that the hostile witnesses evidence cannot be, it's a settled law that they can be used, Lordship. And Lordship has also rightly looked into the 164 statement of the wife of the deceased, she is PW 8. So that statement also. So what my argument is, Lordship, that I'm not denying that there was an incident. I'm not denying, though prosecution has failed, that who has given what blow or how the blows were given. Because, Lordship, in their incident itself, mention is of a wooden block, a bamboo, and a cane. Assault weapon, 3 names are given. The police has written in the seizure list, it's a cane. Otherwise, the witnesses are saying that it is a bamboo. And in the hostile witnesses statement, it is a wooden block. And the police again says that he could not take the wooden block because it was very big. If it was so big, Lordship, he could not take, then how a person can pick it up and hit someone with that? We have to just imagine, Lordship, what they are saying. And Lordship, the seizure of the bamboo was recorded in a CD. Lordship knows that how a CD is to be proved. If electronic evidence is to be taken, it is now settled by the apex court that the certificate is a must. There is no certificate. So that material exhibit, the bamboo or stick or cane, whatever they have given in the court, it is of no value. But still, Lordship, apart from all these things, there are lots of lacuna in the investigation of the police in this case, Lordship. They have not done the investigation properly. But still the fact remains that there is a death, and death of a family member. So, Lordship, my humble submission is that since there was a quarrel, and since these accused, Lordship, they are in jail for last 11 years, 8 months.
How many years?
11 years, 8 months. I've calculated because they were arrested in August of 2011 when the incident took place. And till April of this year, Lordship, 23, it comes to 11 years, 8 months, Lordship. So my humble submission is they cannot be convicted under section 302 based on what is the evidence, Lordship. So even if we take that it was a quarrel, it is to be converted, Lordship. I'm not saying acquittal because 164 statement is there. And though she said that it was tutored, but still the fact remains that there was a death. So it can be converted, Lordship. And in fact, the judgments which I had brought, Lordship, these showed that if there is a grievous hurt, the apex court had converted this kind of incident into grievous 326, 325. 2 cases are there. In one case, 5 years was given. I have given the name of the listener. This is AIR 1968 SC 728, Lordship.
Yeah.
AIR 1968 SC Supreme Court 728. Some part of relevant portion is at paragraph 7, Lordship. That will be page 3 of the judgment. Line 1. 10th line, Lordship. 9th line. Mr. Chakravarti submits that.
1 minute.
Yes, Lordship.
Para?
Para 7, Lordship. Lordship will come to 9th line. That will be page 3 of the judgment. Para 9. Line 9. Mr. Chakravarti.
Para 9.
Para 7, Lordship. Para 7. Line 9. Mr. Chakravarti submits that in a case of this type where 4 blows, Lordship got it?
1 minute. 7.
No. Lordship. No, again.
You get it? No, no. Which one? 1968.
Yes, 1968 SC 728. I had given 2. One is AIR 1994 SC 34. And another is 1968.
1968 AIR
SC 728.
Wow.
Ball versus state of UP.
Baul and another versus state of UP.
Is it para 6?
Para 6, Lordship, in my copy, it starts with, in this appeal, Mr. P.K. Chakrabarti.
No. Just different.
Then, Lordship, before that, Lordship, para 5, the session judge disbelieved the evidence of alibi and
That is
accept.
para 4.
Oh, here I have got 5. Then, Lordship, maybe 6. Then, Lordship, copy will be 6 and line 9, Lordship. And I do not know line there. Mr. Chakrabarti submits that in a case of this type, Lordship, got it?
Yes.
Where 4 blows were hit on the head by 2 persons, it would be difficult to say who hit which blow and whether those blows was responsible for the fracture of the skull. In this I'm mentioning because in our case also the prosecution has not proved that who had given that fatal blow, Lordship, because there was 1 injury, 2 accused. Who had given that fatal blow, that is not proved by prosecution in our particular case. Lordship.
Yes.
Yes. Next para, Lordship, it starts with no doubt the original prosecution case showed that Sadhai and Ramdev both hit the deceased on the head with their lathis. And I'd like to mention, Lordship, in this particular case, the case I'm reading, Lordship, Ramdev was acquitted by the court and Baul, his sentence was reduced to 325 and only the conviction of 302 was against Sadhai, Lordship. So, and Sadhai and Baul had come in appeal. Baul because he wanted that it should be totally removed and Sadhai because it should be reduced or removed. That's right. And Ramdev was acquitted. No doubt the original prosecution case showed that Sadhai and Ramdev both hit the deceased on the head with their lathis. One is tempted to divide the 2 fatal injuries between the 2 assailants and to hold that 1 each was caused by them. If there was common intention established in the case, the prosecution would not have been required to prove which of the injuries was caused by which assailant. But when common intention is not proved, the prosecution must establish the exact nature of the injury caused by each accused, and more so in this case when one of the accused has got the benefit of doubt and has been acquitted. It cannot therefore be postulated that Sadhai alone caused all the injuries on the head of the deceased. Once that position arises, the doubt remains as to whether the injuries caused by Sadhai were of the character which would bring his case within section 302. It may be that the effect of the first blow became more prominent because another blow landing immediately after it caused more fractures to the skull than the first blow had caused. These doubts prompt us to give the benefit of doubt to Sadhai. We think that his conviction can safely rested upon section 325 of the Indian Penal Code. Why I'm mentioning this, Lordship? Because the doctor in his evidence said that it was a grievous injury. The injury on the head, and the doctor also said that if better treatment had been taken, then he could have been saved. That is the evidence of the doctor, Lordship. But it is difficult to hold in a case of this type that his guilt amounts to murder simpliciter because he must be held responsible for the injuries that were caused to the deceased. We convict him instead of section 302 of an offense under section 325 Indian Penal Code and set the sentence of imprisonment for life and instead sentence him to rigorous imprisonment for 7 years. And in our case, Lordship, the accused, both of them, they have already spent 11 years, 8 months in jail. Because the incident, it should be more than 8 months now. Incident took place on 14th, Lordship. So we are on 20, today is 20th. So already 8 months, 11 years, 8 months, some days have gone.
During trial, they were on jail.
Yes, Lordship. They were, because in the record also it is shown they were brought from Hajot. No, Julie? Julie?
Just check the record.
It is mentioned in the this only, Lordship, page 8. Hajoti accused Anil Kujur and Waris Kujur produced from jail Hajot. So they have been produced from jail only, Lordship. And Lordship, the other case, AIR 94 SC, Lordship. here also there was a wooden lathi was given. And in fact, the advocate, he first said that there was no case, pure acquittal should be there. But then at para 3 of my copy, Lordship, I do not know Lordship copy. AIR 94, SC 34. Section 34 पे आई है.
Para?
92. Para 3, Lordship, I do not know in Lordship's copy, it will be 4 or 3. I'm in this appeal, the learned counsel for the appellant submits that the intention to cause the injury.
Para 3.
Yes. I'll read that, Lordship, because 4 things came up here, Lordship. In this appeal, the learned counsel for the appellant submits that the intention to cause the injury, which was found sufficient to cause the death in the ordinary course of nature, was not established. In support of this submission, he relied on the circumstances, namely that the whole incident took place because of a trivial incident. In our case also, it was a very small incident, Lordship, which resulted in a quarrel, here also quarrel, and that the weapon used was only a lathi. And in the circumstances, it cannot be said that the accused intended to cause the death by inflicting that particular injury, which objectively was proved by the medical evidence to be sufficient in the ordinary course of nature to cause death. In other words, he submits that clause 3 of section 300 IPC is not attracted in this case. We find considerable force in the submission. The weapon used is not a deadly weapon, as rightly contended by the learned counsel. The whole occurrence was a result of a trivial incident, and those circumstances, the accused dealt 2 blows on the head. In our case, Lordship, only 1, not even 2. With a lathi, therefore, it cannot be stated that he intended to cause the injury which is sufficient. At the most, it can be said that by inflicting such injuries, he had knowledge that he was likely to cause the death, in which case the offense committed by him would be culpable homicide not amounting to murder. We accordingly set aside the conviction of the appellant under section 302 IPC and sentence the imprisonment for life, and the sentence of imprisonment of life to awarded thereunder. Instead, we convict the appellant under section 304 part 2 IPC and sentence him to 5 years RI. In this case, though it was 304 part 2, only 5 years were given. So my humble submission, Lordship, that if I go through all the evidence now, Lordship will find hostile witnesses, witnesses not supporting the prosecution case. The IO himself did not do a perfect job, but then again, a death was caused. And these people, they have spent 11 years, 8 months in jail. Lordship, they are to be released now with the year that they have already spent in jail, with the time they have already spent in. That is my humble submission.
I've checked the records. They were not inside for so long.
Achha.
They were bailed out. The incident occurred on 14/8/2011. And after 3 months, 19/12/2011, they were bailed out. Both of them. On 19/12/2011. So they were released on bail after 3 months. 12/2011. And then they were again re-arrested. They did not appear. They were absent without steps. They did not appear and they were re-arrested on Anil was arrested on 6/9/2018. Anil arrested on 6/9/2018. Although in the order sheet, it is written 2019, but the subsequent orders were of 2018. So that was perhaps mistakenly written. So 6/9/2018, Anil was arrested and 4/10/2018, Warish was arrested. After that, they were in jail. Thereafter, they were in jail. They were in jail since 2018.
1920, 2022, 23. Then also, Lordship, the 5 years plus earlier time. So they have spent more than 5 years.
Earlier, it was
So my
3 months, 5
judgment,
years.
Lordship, it says that 5 years is sufficient. And
Let us not go according to that.
yes, Lordship. But then, Lordship, if we go strictly, then Lordship, how have the prosecution proved that these two persons have done?
That also,
I'm-
that
That my friend has to accept, Lordship. Where have the prosecution proved that they have done the incident? And if they were wrongly arrested and they are wrongly kept in the jail, Lordship, then they can claim for compensation, Lordship. There is no evidence that they have done it. Exactly. We do not find anything, Lordship. But still, I'm making a humble submission because, okay, there was a death. That's why one incident took place. Otherwise, how do we explain the death of that person? Lordship? That's why. Otherwise, the prosecution has not proved that these two people have really killed this person with that wooden log or whatever, a bamboo or a cane, with what happened. And the injury is one in the head, occipital region, and the doctor says it is a grievous hurt and grievous injury, and that if proper treatment is given, he could have been saved. So where is the intention also, Lordship? Mens rea is not present there. So I think, Lordship, again, I'll fall back into apex court judgment that apex court said 5 years is sufficient. One says 7, one is 7 years, one is 5 years. And if what my friend is saying, from 18 also, if we calculate, so they have stayed more than 5 years in jail, Lordship. That will be my humble submission. Thank you.
may please the Lord. In fact, their alternative argument would come into place only if I can prove that these are the person who are actually killed the deceased person. Now, what I can learn is 164 statement by Anjali Kujur will not be the decisive factor in reaching the conclusion that they are the ones who had killed, because 164 can be only for corroboration and contradiction. Corroboration, there is no question because she has resigned from her statement. Contradiction is proved by the police officer. So 164 statement in fact goes, it has no value in the facts of the instant case. Now what I'm left with only circumstantial evidence. It is seen that yes, these are the person who had done the offense, but the witnesses have all turned hostile. So what can we do? We cannot do anything. Hostile doesn't mean that their evidence would be brushed aside totally. Of course, I can take help of certain positive statements supporting the prosecution. Those statements also I do not get in my humble submission. Any positive statement supporting the prosecution. What I will have to show is circumstances in the case. Eyewitnesses, there are none. Cannot rely on these evidence. Now, circumstances, as your Lordship has already seen and what my learned friend had produced, the particular paragraph of the judgment, there it is said, Trimukh Maruti Kisan, this has been placed a lot of times by Ms. Bhuiyan also. There it is said, when a murder takes place inside a house, in the secrecy of a house, then we cannot get the chain of circumstances that is required in a normal case. That a chain has to be complete. There, in such cases, the chain can be shorter. The evidences can be lighter. Lordship has that particular paragraph has already been produced by the learned session judge. I can place the judgment also, page number 53. I'll just place that few lines and then I'll go to the circumstances. 53, page number 53.
Yes.
I did not place it from there. I could have placed the judgment itself, but then it's reflected, it's produced here. Paragraph, page number 53, last paragraph of the particular page.
Yes.
Lordship got it. In the case of Trimukh Maruti Kirkan versus State of Maharashtra, reported in so and so, Supreme Court has observed that when an offense like murder is committed in secrecy inside a house, the initial burden to establish the case will undoubtedly be upon the prosecution, but the nature and amount of evidence to be led by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. Because in other case, we'll have to show that the chain is totally complete. There is no gap. There is no loophole in between. But in cases where it is committed in secrecy of house without the knowledge of anyone else, then the chain can be shorter. Now here, in order to show what are the circumstances that I have, the few circumstances that I have, First, whether the accused person and the deceased person were at the same place at the time of occurrence. Now, the evidence, Lordship will go to paragraph, page 22. There, I think the wife of the accused, wife of Waris, she stated that Waris was there at the time of the occurrence. Page number 22, Lordship will see. Page 22, this is the evidence of the wife of Waris. She does not talk about her son Anil, but she talks about her husband Waris. Page number 22, second paragraph. After she said we are living separately, we need not go into that. There is again confusion whether they are staying separately in the same compound. And at one place she's saying that Anil is staying somewhere else near the river. But whether the accused and the deceased were present at the time of occurrence at the same place, Lordship will go to page number 32, second paragraph, second line.
32 or 22?
22, Lordship, I stand corrected, 22. At the time of occurrence, my husband, deceased Marshal, his wife, and I were present at home. So, barring her son Anil, she did not implicate. Anil, she said, I informed him later he came. But she said her husband, Marshal, his wife, that is page PW number 7, and I were present at home. So this shows Waris was there at home at the time of occurrence. Then Lordship will go to page 23, the next page, in order to reiterate the same point, like Marshal was there. 23, paragraph, page number 23, Lordship will go to the last line of the same first paragraph. On the day of occurrence also, Marshal came home drunk and quarreled with boys who were playing ball in our courtyard. So Marshal came drunk. On the day of occurrence, he came drunk and he was quarreling. Next paragraph, she says that she did not go out. We did not go out of our house since Marshal used to create the nuisance daily after getting drunk. At that time, Marshal's wife Anjali was serving us milk. We came out first, followed by my husband and daughter-in-law. After coming out, I saw Marshal lying dead. That did not require. But the fact remains, they were inside the house at the same place and same house they were present. Both the accused Marshal, Waris, and the deceased Marshal. They were there. Page number 22, 23 shows that they were present. And then my learned friend Ms. Saikia said that there is no evidence that his body was found inside the house of Waris. But I see one sentence, page number 17, Lordship will see, the body was taken out from the house of Waris. This is what the witness said, PW number 4, he said, page number 17, he is Anil Karmakar. Hearing hue and cry, Lordship will see the first paragraph. Having heard a hue and cry in the night that day, while I was at home, I came out of the house to the road near the accused duo's house. Accused duo's house, same house, and learned that Waris Kuzur's son, Marshal Kuzur, had died. The dead body of Marshal Kuzur was brought out of accused Waris Kuzur's house. So body was inside. And when he reached, his body was taken out from Waris Kuzur's house. So here, section 106 comes. He has to explain Waris. The body was inside. Then he says, I don't know how Marshal Kuzur died. Thereafter, he turned hostile. Now, what Waris said, Waris, in his 313 statement, he simply denied, he did not say anything. On this, Lordship will go to the question number. PW4 stated, question number 5, page number 36. This is the examination of 313 of Waris Kuzur. Page number 36, question number 5. Of course, that question was not put in that manner.
So
Stated, the PW4 stated that on the day of occurrence at night on hearing Halla and came to know that Waris Kuzur has died, it is not a fact. That question was not put, but that point they can take that what prejudice was caused. But the fact remains, he did not explain anything in his 313 statement. He simply said, no, it is not a fact, I'm innocent. The burden lies on him to explain how his body reached, how the body reached his place inside the house. So there was no explanation from his side how the body reached, how the body was taken out. And page number, Lordship will go after that. And what it has come out in the evidence is that everyone was drunk. Marshal was drunk, even the wife, Anjali Kuzur, was drunk, wife of Waris. All were drunk. Page number 20, Lordship will see. Page number 20. At around 9 p.m., page number 20, the first few sentences of the deposition of Anjali Kuzur, wife of Waris. On 9 p.m. on 14 August, deceased Marshal Kuzur came home after getting drunk. At that time, I was at home having my dinner. So he came drunk and there was an wooden post lying near his body. So the fact remains, everyone was drunk at that point of time. Marshal came home, Waris was there. Marshal came home, Waris was there. Anjali Kuzur was also there. Thereafter, everyone turned hostile and they said that he was found dead. There was no explanation from Waris Kuzur what had happened on that night, in spite of the fact PW4 had stated that the body was brought out from his house. So first circumstance, they were together. Second circumstance, PW4 said body was brought out from inside the house of Waris. Third circumstance, an wood lying near the house of near the body, and that stick. Fourth circumstance, a stick was seized, being led by Waris Kuzur. Lordship will see the Caesar list once. The Caesar list is at page 64. This will not be 27 recovery, but I'm stating that this is a circumstance. Page number 64. 64, what he said is, Rishikesh Dwara of so-and-so hereby sees, on being led and shown by Waris Kuzur in his own house after commitment of the offense of this case by the accused, the seizure is made on 15/8 at 8 a.m. in connection with the case. So this was, the seizure was done on the next day. On the next day at 8 a.m. After police reached on the night itself, but then the seizure was made. Lordship will see, even page 30, Lordship can see the deposition of the IO, page 30. Page 30, it's written the second paragraph. I did not mention in Exhibit 3, but he said I did not mention in Exhibit 3 that Waris Kuzur led me and showed the material. In fact, he has mentioned in Exhibit 3 that it is led and shown by Waris Kuzur. So here, this is one of the circumstances that the stick was recovered from the house of Waris Kuzur on being shown by Waris Kuzur as is shown in the Caesar list. That is another circumstance. Then they were arrested. Then the doctor said it is homicidal. Of course, taking at a particular time would have saved him. That is a statement, a bold statement made in his cross-examination. But the fact remains, he had head injuries. There was hematoma. And what he said is there was fracture also, I believe. There was a fracture on the cervical vertebra starting from so-and-so. this is a homicidal death. This is the fifth circumstance. So, and Lordship can also take recourse to section 114 of the Evidence Act in order to Lordship presume certain facts. Section 114 of the Evidence Act, Lordship can see for a second.
Yes.
Section 114. Court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. So my circumstances, although are very less, but their presence, body being found inside the house of Warris, then wood lying near the place of occurrence, a lathi being seized, a homicidal death. These are the circumstances which points to the guilt of the accused, Warris, especially Warris. Anil, it's little difficult because I don't find, because what they say, Anil and Warris are staying separately, but in the same compound. And accused was in the middle. Accused house is in the middle. So as far as Warris, I would say there are few circumstances. Anil, I find it difficult, the circumstances, because mother said Anil was, she called Anil, Anil came later. But one statement from PW forced evidence that what they say, I came out of the house to the road near accused duo's house. So he said accused duo's house, both of them stayed together, and learned that Warris Kuzur's son Marshal Kuzur had died. The dead body of Marshal Kuzur was brought out of accused Warris Kuzur's house. Thereafter, he got specific and said that it was Warris Kuzur's house. So in my humble submission, these are the circumstances. And if your lordship decides that, yes, they are the perpetrators of the crime, then quarrel part, I don't see, apart from the FIR, there is nowhere in the substantive evidence of the witnesses about the quarrel part. Quarrel is only there in the
But they
FIR.
were all drunk.
Yes, they were all drunk. In the FIR, it is said following a quarrel, there was a assault. There was a marfit kind of a thing. But quarrel, nowhere in the evidence of the witnesses I find that they spoke about quarrel in their substantive evidence. In their hostile part, they have stated so many things, but that will not be relevant. So converting it to 304 would be difficult, because FIR is not a substantive piece. To bring it within 304 or by taking recourse to exception 4, mutual fight. Exception 4 of 300 lordship can see, of 300 of the IPC, they have to prove their case to come within the exception. But exception is difficult to be taken resort to, because quarrel is only there in FIR. Oh, what? They wanted to show some from somewhere else that quarrel is there. For the set. 164. Quarrel, what my subjective correction, I found it only in the FIR. 300 lordship will see 300 exception 4. Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of a passion upon a sudden quarrel, and without the offender being taking advantage, undue advantage, or acted in a cruel or unusual manner. To bring it within that this is culpable homicide, but it is not murder, they have to bring the case within these ingredients. But quarrel, for subject to correction, what she is saying, there are.
PW5. I'll submit lordship. Let her finish.
PW5,
We cannot just pick PW4 something and PW5 something. If we take it, we have to take it fully, Lordship, and PW5 is there. To me, page 21, cross by prosecution.
Well, let her place done. I did not find subject to correction. This is my humble submission.
Because this statement was by prosecution themselves, Lordship, it was proved. This page 21, it's there by PW 5, the mother. And she said, at first my elder son Anil Kuju fought with him, later his father Waris Kuju.
But this is the hostile part.
In the evening.
In the evening of 14/8.
This is hostile.
And
This will all
Lordship-
go.
And Lordship, what my friend is saying, that
He, after that, he was enlarged on bail and he is now due to surrender on Tuesday. Now, in the meantime, if your lordship recalls, for his son's, for looking after his son, he was enlarged. That was a ground on which the appellant, that is the accused, was enlarged on bail. His sentence was suspended. Now, there's some problem with his son. We have, yesterday evening, we came to know we have filed the interlocutory application. And today morning, I could have been, what had happened was, there was a notice in the notice which came that the division bench to his notes. I had a confusion. That is why I missed the mention. That is why I'm again making a mention for listing the matter tomorrow. But if Tuesday, he'll have to surrender. We have filed another application.
Tuesday, there are few order matters on board.
Orders, this will come in order in the orders column. Tomorrow, lordship.
Tuesday, you can't have it. He has to surrender.
Surrender on Tuesday,
10:30 will pass the order.
10:30. No problem, 10:30 Tuesday.
On Tuesday.
Tuesday, that's better. Instead of taking up in a rush manner.
Lordship.
Tuesday.
Okay.
wait, please, your lordship. Now let me reply to what my learned friend has said, lordship. 3 circumstances she is mentioning. One is that the body was brought from Waris Kuju's house. Lordship, she is relying on that, for that she is relying on the evidence of PW 4. Lordship. It is the sketch map. Here, lordship, the place of occurrence is B, lordship. Lordship will see it is not inside the house. B, it in.
Something is wrong with your mic. Yeah.
Okay. Lordship didn't hear me anything.
No.
Okay. Lordship, 3 circumstances were enumerated by learned PP, and first one was that the body was brought from Waris Kuju's house, and for that she relied on the evidence of PW 4, lordship. PW 4, again she herself says that PW 4 was a hostile witness. His evidence cannot be accepted. That is second. But I'll take lordship to the sketch map, lordship, page 72. And here, lordship, the place of occurrence is outside all the houses. B is the place of occurrence, lordship. At the page 73, it is mentioned, lordship. The index is at page 73. A, it indicates the storehouse. B, it indicates the PO. So, what PW 4, on one side, the prosecution is saying that he is hostile, his witness evidence is not to be considered. And another, on the next breath, they are saying that he said that the body was brought from inside. But his evidence, Lordship, when I read his cross-examination, Lordship, I'll read. The two accused persons live in separate house. This is Marshall used to live separately in between. The house of accused Anil is about half a furlong away from that of accused Waris. The house of deceased Marshall is also about half a furlong away from that of accused Waris. It was a dark night in the night of occurrence and it was raining. When I reached the place of occurrence, I saw a lot of people gathering near the house of accused. Seeing Marshall's dead body at the courtyard of Waris's house, I left. So it was not inside, Lordship. And he came after the incident. None of them are eyewitnesses, and according to him, Lordship.
It's the courtyard.
Yes, courtyard. And as per the sketch map also, Lordship, it is there. It's a courtyard.
B.
B is the PO, Lordship. It indicates the PO. So there is no question of Waris Kuzur explaining. Now, Lordship, let's come to PW5, who is the mother of the deceased, mother of one of the accused, Anil, and wife of the Waris, Lordship. What she says, Lordship, she was also declared hostile, but when in her statement before the police, she had said, because prosecution cross-examined her, that is at page 21, Lordship. Crossed by prosecution. I'm reading the quoted remarks, Lordship. In the evening of 14/8/11, a quarrel took place in connection with the cows eating paddy saplings. Everybody was under intoxication at that time. At first, my elder son, Anil Kuzur, fought with him. Later, his father, Waris Kuzur, assaulted him with a lathi and then hit him on the head with a piece of wood lying nearby. Immediately, blood started oozing out of Marshall's mouth and chest, and he fell down. After a short while, he was taken to Rangapara Hospital and doctor declared him dead. This was what she had stated in 161. And Lordship, again, I will come to the next page, page 23, Lordship. Page 23, what she is saying, Lordship, in her cross-examination. Second para, Lordship. No, in first para itself. Accused Anil had been living separately since 2 years prior to the incident. He lived at some distance from us near the bank of river. In between my house and that of Anil, there are houses of other persons and playground. My husband and I live in the quarter provided by the garden authority. We constructed a house on our land and gave it to Marshall. Except these two houses, there is no other house in our compound. This is Marshall used to drink alcohol and create nuisance. On the day of occurrence also, Marshall came home drunk and quarreled with boys who were playing ball at our courtyard. Initially, we did not come out of our house since Marshall used to create nuisance daily after getting drunk. At that time, Marshall's wife, Anjali, was serving us meal. Having heard hue and cry, I came out first, followed by my husband and daughter-in-law, Anjali. After coming out, I saw Marshall lying holding a post. He was dead. So, Lordship, she is also hostile witness. PW4 is also hostile witness. They want to rely on some part of PW5, what she is saying, some part of PW4, what he is saying. That cannot be, Lordship. It has to be taken as a whole. If we accept it or we reject it. It has to be like that. And then when she is saying, Lordship, now that the circumstance that body was brought from Waris Kuzur's house is not there. It was in the courtyard, and that courtyard belongs to Marshall as well as the Waris Kuzur. I told you. The second circumstances, what they are saying is that what the prosecution is saying, that bamboo brought from Waris Kuzur's house. Now, Lordship, already I mentioned about it. The Caesar list, they are relying on the Caesar list.
Bamboo to
60.
seize one.
Huh?
Bamboo to seize one.
Oh, stick. The witnesses are saying, Lordship, that if we go by the witnesses as well as the IO, Lordship, that there was a log which he could not carry, there was a wooden. Then again, the witnesses are saying there was bamboo. The Caesar witnesses are saying it was a bamboo. And some are saying that the bamboo, they had signed the bamboo was they had not seen the. And what the Caesar is saying, Lordship, cane stick, Lordship. Stick, if we understand, stick is something, Lordship, which means stick, Lordship, a piece of something that's fallen. Stick.
It says with two notes on it.
Huh. So that is stick. With that stick, Lordship, could that injury have taken place? Because they have said this, we have to go by what they have said. What is their story? What is the prosecution story, Lordship? As per prosecution story itself, it was not a wooden thing. It was not a bamboo. It was just a cane stick. Cane stick, Lordship, understand, we have in northeastern region, the cane thing. With that, Lordship, can the fracture to the occipital region happen? When we were asking for alternate sentence, Lordship, we have been lenient. But then this is a case of pure acquittal, Lordship. We were lenient because there was a death, yes, that we are accepting. But then the mother herself says that he was outside and he had something to do with the boys playing in the courtyard, and then later on they came and they found him lying on the yard. And as per the sketch map also, he was in the courtyard, not inside the house of Waris Kajur. And if Waris Kajur, what he led to is one cane stick, and this was also not sent to for FSL. There was no blood report that this was the weapon which was used, because the witnesses are saying it was a bamboo thing. They everybody common stick. Bamboo, Lordship, one of the witnesses says that it is found in every household. That's true. And Lordship, the recovery, the IO says that recovery was made when they had taken a videography. Videography was not proved. So the evidence of the videographer is important to the extent that he had not given a certificate. And videography, Lordship, it is now established by Apex Code that the certificate is a must if they want to rely on that. And Lordship, this one cane stick was recovered, whereas the prosecution story is that it was a bamboo or a wooden. So Lordship, that circumstance that the bamboo was brought from Waris Kajur's house fails, because that type of stick is found. The witnesses themselves, prosecution witnesses themselves are saying that type of sticks are found in every house. And cane stick, Lordship, with cane stick, I do not think that kind of injury can happen. And third circumstance they said was that the doctor said that it was a homicidal death. Lordship, if we take doctor's evidence, it has to be taken as a whole. The doctor in cross, what he says, I did not mention in my postmortem report that the hemorrhage seen in the membrane, brain or spinal cord, whether it is internal or external. Aberration and laceration, as I have mentioned in my postmortem report, are not grievous. Fracture in cervical and occipital region are grievous in nature. Such type of injury may be cured if the patient gets better treatment. The patient was brought before me from Rangapara PH. So, Lordship, was there an intention to kill, even if we take doctor's evidence that it was homicidal? The injuries were grievous, but whether there was an intention to kill. First of all, the prosecution failed that who has killed. There is nothing in the prosecution evidence. All the witnesses are hostile. Only the person who PW2 who wrote the FIR, Lordship, only he was not declared hostile, but then he has not seen, he heard. And some of the other witnesses also, Lordship, I have marked, they were all hearsay evidence. There was no direct evidence. In these circumstances, Lordship, can the conviction under 302 survive, Lordship? It cannot, Lordship. Prosecution case is totally weak and they are wrongly being convicted under section 302 and read with section 34. And again, prosecution here is saying that they do not have anything against Anil Kuzur. The case was under section, the conviction was under section 302 and 34 IPC. That means there has to be a collusion of mind to do the act, to do the crime. If they do not have anything against Anil Kuzur, I gave one of the judgment, Lordship, when one person is let out, the acquitted on that same circumstance, Ramdev was acquitted, Lordship, and Sadhani was there. He was convicted. Apex court said that if one is acquitted on the same charge, whereas there were two injuries, still if one is acquitted, the other one cannot survive. And it was converted to 325 and 5 years. Here also they have spent more than 5 years, Lordship. So, Lordship, my humble submission, if prosecution is not accepting alternate solution, we need a clear acquittal, Lordship. That is my humble submission.
There cannot be any reply to the reply, but only on that picking up sentences, what my learned friend said, I have to take everything in total. But hostile witnesses doesn't mean that we have to brush aside the entire statement, whatever supports the prosecution. So whatever has supported the prosecution, I have only taken those statements. And stick and what I find is there are two, stick and bamboo, there are two weapons, not weapons, things that were used. Because PW5, the wife said initially, Waris has hit him in her hostile part. Waris have hit him with a stick, thereafter with a bamboo. So there were two things, one stick and one bamboo. Bamboo was not seized, stick was seized. That is, I think, the confusion there.
No, wood was also there. Wood was there.
Oh, here, wood. I mean, the wood which is bigger and what is shown in the...
That was not seized.
What was shown in the sketch map, that is not seized, but the stick which he used initially, that was perhaps seized.
Wooden post.
Her name is D. Saikia, Leonard Amicus Curie, in criminal jail, year 2019. Also, her name is R.D. Majumdar, Leonard Amicus Curie, in criminal appeal jail, 51/2019. Also, her name is S. Jahan, Leonard Edition. Hearing complete. Just one is.
Highly obliged, Lordship.
Deeply obliged, Lordship. In this case, a few of the evidence has been recorded in your Lordship's court. I have no objection. Your Lordship takes up the matter.
That's not a problem, actually. You didn't trust him. Please not suggest.
That's not.
That's not an issue. The first morning's order was wrong, actually.
No, he also sought for adjournment, but judgment has not been passed by your Lordship, but evidence was recorded of few of the witnesses. Here also few of the witnesses in the court of Lordships.
We have no issues. If you have any problem, you can tell us.
Lordship.
If there's any issue, you can tell us.
I'm ready, Lordship, otherwise. I'm all faith, Lord.
The judgment was not passed.
Judgment was not. Therefore, Lordship.
Lordship can take up. We'll take your Lordship to the FIR at page 4. The date of occurrence is 3/9/2009. Humble submission is that around 5 p.m. today, when I was not in my home, my father and the said accused were roaming around together, and thereafter they went to the house of the accused where an altercation followed by a quarrel took place between them. This is very important, Lordship. Altercation and roaming, altercation and all these things. Then the accused suddenly stabbed on various parts of my father's person with a dagger and caused him grievous injury. As a result, my father became unconscious and kept lying in the house of the accused. This is also very important. The accused fled away from the place of occurrence after stabbing my father. Later, the villagers, after seeing my father's critical condition, contacted 108 ambulance service and took my father to Swagat Hospital. This is also very important, Lord. Bongaigaon. But shortly after the arrival at hospital, my father died. The dead body was still in the hospital, so I pray for so and so. Now, if I take your Lordship to the deposit, there were 12 witnesses were examined, PWs, and PW9 was declared hostile, the wife of the victim. Now I take your Lordship to the evidence of the PW9 who was declared hostile at page 24. Page 24. PW9, Sujola Goyari. Good, Lordship, good.
Yes.
I know the accused person in the dock. His name is Lina Goyari. The name of his father is Kenta Bosumati. The informant Shorag is my son. The occurrence took place in 2009 on 3rd September. On the day of occurrence at about 4-5 p.m., I went to nearby river to take bath. While I came back after taking bath, I saw my husband in the serious injured condition nearby my house. He was blood-bathed. I did not find anyone nearby the place of occurrence. When I came near the body of my husband, he was still alive and asked me to give water. This is important. But when I came back with water, my husband was not in a position to speak. I asked my husband about the accident, but he could not state. When he was taken to Swagat Hospital at Bongaigaon, he was alive, but not able to speak. Immediately on arrival at the hospital, he expired. Police went to the hospital and did the inquest of the body and forwarded the same to the postmortem examination. My son lost the FIR. Police recorded my statement. The witness has been declared hostile as she is allowed to be cross-examined by the prosecutor. Whatever she stated in above, this is very important. Now the prosecution has examined. It is not a fact that I stated to police that I saw accused Lina Bosumati nearby my injured husband, and he was armed with a dagger. It is not a fact that on my arrival, the said accused person fled away. It is further not fact that I stated to police that on my queries, my husband told me that accused Lina Bosumati had caused him hurt with dagger. By defense, it takes 10-15 minutes on foot from my house to the river. When I was taking bath, a few young boys told me that a quarrel had been picked up by someone. This is very important, by someone. They did not inform me with whom the quarrel was going on. Immediately I rushed to my house. After coming back, I saw my husband in a pool of blood. I did not see anyone nearby. After my coming back, the other villagers too came to our house. Immediately, my husband was taken to Swagat Hospital by 108 ambulance. This is very important. On arrival, it is at the hospital, he was declared dead. Police went there, but I cannot remember when and how many days after. Now, Lordship, I take your Lordship to the... Now, if I take your Lordship to the page 18, witness deposition of PW6. page 18 lordship body. I know the complainant. I know the accused Lina Basmati. Around 4 p.m. on the day, there about 3 years and 3 months ago, I was at home. Then I heard that accused Lina Basmati had stabbed Ganesh Mutwatari with knife. Samram Basmati, brother of Ganesh Basmati, gave me the information. This is also important. But Samram Basmati was not examined. Gave me the information. I immediately came to the residence of Ganesh and saw Ganesh lying in an injured condition. I saw cut injury in the chest of Ganesh. Blood was coming out. On being asked, Ganesh told us that accused Lina had injured him by stabbing him with knife. At that time, there were many people in Ganesh house. Ganesh was taken to hospital by 108 ambulance. He died on the way. His statement is that there were at that time there were many people in Ganesh house. Then why these people were not examined? Why these people were not examined for corroboration? They were independent witnesses. The people who were gathered in the house of Ganesh, they should have been examined for corroborating. Why they have not been? If it is a if the deceased has told him that Lena has stabbed him, now the cross side. I did not witness the incident. Police interrogated me in connection with incident. In my statement to the police, I did not say that Chamram informed me that Lena has stabbed Ganesh with knife. Why? It is not a fact that accused Lena did not kill Ganesh by stabbing him with knife. It is not a fact that Ganesh had died before I reached the place of occurrence. It is not a fact that Ganesh did not tell me that accused Lena had stabbed him with knife. I did not say in my statement to the police that at that time there were a lot of people in the place of occurrence. I did not see accused Lena in the place of occurrence. Now I take your lordship to page 20, the deposition of PW7, the mother of the deceased. The complainant, Orang Gosamatari, is my son. He should be grandson, lordship. I know accused Lena. We are from the same village. The incident took place around 3 years ago, around 3-4 p.m. I went to Lakhi Bazaar for shopping. While I was in the market, Sumitra informed me that my son Ganesh had been stabbed by accused Lena. So Sumitra informed the mother of the deceased. If you presume that Sumitra was an eyewitness, then she should have been examined. Sumitra informed the mother of the deceased that Lena has killed, that my son Ganesh had been stabbed by accused Lena. Then why not Sumitra was not examined? She would have been vital witness to establish. He was not examined. Even the PW6, from whom he came to know that about the incident, Chamram Basumdar, he was also not examined. Sumitra might have been an eyewitness, so she should have been. And there is no PWs are eyewitnesses. Not a single person is eyewitnesses. On getting the information, I immediately came home. I saw Ganesh lying in the courtyard. Someone is telling in the room and someone is telling in courtyard in an injured condition. I saw injury in his chest and both hands. Blood were coming out. At that time, Ganesh was in a position to talk. On being asked, Ganesh told us that Lena had stabbed him. Ganesh died while he was being taken to hospital. Gross side. I did not witness any occurrence. It is not a fact that I did not say in my statement to the police that Sumitra informed me that Lena has stabbed my son Ganesh with dagger. It is not a fact that accused Lena did not kill my son Ganesh by stabbing him with dagger. This is not a fact that Ganesh had died before I reached the place of occurrence. It is not a fact that Ganesh did not tell me that accused Lena has stabbed him with knife. Now, Lordship, if your Lordship kindly come to the deposition of the PW9, she saw her husband lying in her house in a critical condition. deceased has informed him that to bring a glass of water. He went there. It will take hardly 1 minute or 30 seconds to bring a glass of water. And when she returned, she saw he could find that he could not able to speak. Now the PW 6 and 7 is telling that he could able to speak. The PW 6 came from his house, which took at least 5-6 minutes. And the mother, that is the PW 7, she came from market. And in the FIR, it is written that after seeing the deceased victim lying in the 108 ambulance was called. The question of declaring that Lena has stabbed by the PW 6 and 7 doesn't address. There is no declaration, Lordship, no declaration at all. Cannot be, Lordship. Within that very short period of time. PW 7, who is the mother of the deceased, came from Bajar, which is around 5-6 kilometers. Can it be possible? And he was in a serious condition. And why the PW 9 was declared hostile? This is very important. Why? Because he told that he could not able to speak, and whereas the PW 6 and 7 is told that he was able to speak. Therefore, the PW 9 was made hostile, declared hostile. And other witnesses, Lordship, all are, nobody is eyewitnesses. I will take your Lordship to page 60, the PW 5. Accused Lena Boshimatul is my nephew. Caesar witness, Lord. Complainant Shaurang Boshimatul is my husband's wife. Ganesh Boshimatul, the father of the accused, had died around 3 years ago. When police came to our village, I came to know that Ganesh Boshimatul has died. Police took me to the residence of accused. Police seized one dagger from my house. And I put my signature on the Caesar list as a witness. Exhibit 3 is the Caesar list, and Exhibit 3.1 is my signature. Today I have seen that dagger in the court. Material Exhibit 1 is the said dagger. Now the cross part, Lordship, very important. I did not witness the occurrence. I came to know about the occurrence only when the police came. The dagger was found on the road. Dagger was found on the road in front of our house. I do not know as to whom the aforesaid dagger belonged. I do not know what is written in the Caesar list. It is not read over to me. In his deposition, he stated that the dagger was seized from his house. And in cross, he is telling that dagger was found in the road in front of his house. There is material contradictions are there in between all the witnesses. Now I will take your Lordship to the page 22, PW 8. I know this is Ganesh. The incident took place around 3 years ago. Police seized the dagger from the house of Tenganarjani. Here also house of Tenganarjani. At that time, I showed the accused in the house of Tenganarjani. After seizing the dagger, police prepared the Caesar list, and I put my thumb impression there. Today, I have seen the said dagger today in the court. Now cross part is made. I went to the house of Tenganarjani just after police had arrived there. I saw blood sticking into the dagger. Blood sticking. I do not know what is written in the Caesar list. I did not see the place in Tenga's house where from police brought the dagger. Now I take your Lordship to the deposition of the IO. At page 27, PW 11. On 3/9/2009, I was working an attached officer at Bijli police station. That day, when officer in charge of Bijli police station received a written ejahat from Charang Boshimatul, he registered Bijli PS case number so-and-so and entrusted me with the charge of investigation. On 4/9/2009, I went to Swagat Hospital, Bongaigaon. The dead body was there. I had inquest on the dead body in the hospital itself and sent the dead body to R&B Civil Hospital, Kokrajhar for postmortem examination. I obtained signature of the witnesses inquest report in the hospital itself. Thereafter, I went to visit the place of occurrence. I prepared sketch map after visiting the place of occurrence and examined witnesses. On 7/9/2009, I arrested. This is an important notice. On 7/9/2009, I arrested accused Lena Gueri, alias Basumatri. After interrogating him, when he was interrogated, he said that he would show the dagger with which he had committed the incident. Thereafter, I went to the house of Tenga Nazari along with him, the accused, and as shown by Lena Gueri, I seized the dagger from Tenga Nazari, house in presence of the witness. Exhibit 3 is the seizure list, and Exhibit 3 is my signature. Thereafter, I sent the accused to the court. I collected the postmortem report. After completion of investigation, I submitted the charge sheet against accused Lena Gueri, alias Basumatri, under Section 302 IPC. Exhibit 4 is the charge sheet, and Exhibit 4(1) is my signature. Now, cross. Around 9:45 p.m. on 3/9/2009, I was entrusted with the charge of investigation. I reached Swagat Hospital at about 9:45 a.m. on 4/9/2009, and there I met the accused, village head, so-and-so, Bolen Borom, Nasher Basumatri, and Sogam. I took their signature in the inquest report as witness. The inquest report was prepared in their presence. At 1 p.m., I sent the dead body to R&B Civil Hospital for postmortem examination. Around 3:15 p.m., I went to the place of occurrence. A section of the 2nd APTF battalion also went with me. Sujola Gueri, the wife of the deceased, showed me the place of occurrence. I recorded the statement of witnesses at the place of occurrence and in the hospital. I recorded the statement of Sujola Gueri, Gogo Basumatri, and Khagan Basumatri at the place of occurrence. I prepared the sketch map at the place of occurrence. On the north of the place of occurrence, there is a garden of betel nut and other trees. Village road in the south, Gagaram Gueri's house is in the east, and Bhavani Basumatri's house is in the west. The accused was apprehended by the villagers on 6/9/2009. In his deposition, he stated that he has arrested him on 7/9/2009, and here he stated in his cross that villagers has apprehended him on 6/9/2009 and handed over to the police station. I was on law and order duty that day. The distance between the place of occurrence and the place from where the dagger was seized is about 5-6 kilometers. At that time of going to recover the dagger, I took Tiklu with me as witness. There was no blood stain on the dagger that I seized, whereas the PW8 has stated that there was a blood stain in the dagger. And I was telling that there was no blood stain.
No fingerprint.
I did not take the fingerprint of the accused and of the one in the dagger. I do not remember whether I gave a copy of the seizure list to the owner of the house or not. It is not a fact that the seized dagger is not one related to the incident and that the dagger belonged to the owner of that house. How can he come to the conclusion that this dagger was the weapon used? When he has not said there is no blood sticking in the dagger, he has not taken the fingerprints of the accused as well as from the dagger. How can he come into conclusion that the incident was carried out by the deceased victim? Accused person. Oh yes, Lordship, if you had kindly Lordship, page 28, that cross part I forgot to point out. I had 28 at around 9:45 p.m. at 3. I was entrusted with the charge of investigation. I reached the Swagat Hospital at about 9:45 a.m. or 9/2009, and there I met the accused. If there was any intention of the accused person to kill this Ganesh, why he was present in the hospital? He would have fled away. Voluntarily went there to see. So there cast a doubt, serious doubt. And he was not arrested on that day. If the PW 6 and 7 has stated that Lena has killed him, stabbed Ganesh, then why on 4th, when he was present in the hospital, why he was not arrested? There were many villagers in the hospital. They should have apprehended him and hand over to the police, or police should have arrested him. Police was there, present in the hospital. Therefore, PW 6 and PW 7 depositions are not trustworthy, absolutely baseless. Only to no dying declaration. It cannot be termed to be a dying declaration. And the Lanet Court below has stated that it is a dying declaration. Can it be delivered? If I am the accused person who was present on 4/9/2009, why he was not arrested? This is very important. This casts a serious doubt. And nobody's in the incident. In the FIR, Lordship, there was a quarrel. They went out for roaming. Thereafter, altercation took place. Then quarrel, and thereafter, Lena has stabbed Ganesh. In the deposition of the witnesses, PWs, where the quarrel, word roaming, word, no whisper about quarrel. So how this FIR has been filed? On the basis of presumption? It's absolutely false and baseless FIR which has been filed, and the appellant has been subjected to. There is no motive. In the depositions of the PW, where there is motive, is there any motive to show that yes, accused has stabbed Ganesh? Now I take your Lordship to the judgment. Oh, Lordship, if I take your Lordship to page 32, 37, the accused under section 313. 32. Examination of the accused under section 313 here. PW1. Sri Shauram Basumatari has deposed that on 3/9/2009 he got information from Sujola Basumatari that you had stabbed his father with dagger. What do you want to say in this regard? He has adduced false evidence. I did not stab him. The clear-cut statement. PW2 Gajan Basumatari has deposed that Ganesh's mother told him that a quarrel had taken place between you and Ganesh Basumatari, that you had stabbed Ganesh Basumatari with knife, and that he had died. What do you want to say in this regard? I do not know about it. PW3 Sri Maheshwar Basumatari has deposed that you stabbed Ganesh Basumatari with dagger, and Ganesh Basumatari died. What do you want to say in this regard? He had adduced false evidence. PW5. Langaram Narjari has deposed that on a day around 3 years prior to his adducing evidence, police took you to the house and seized the dagger. What do you want to say in this regard? He has adduced false evidence. PW6 Hagen Basumatari has deposed that one afternoon around 3 years prior to his adducing evidence, he heard that you had stabbed Ganesh Basumatari with dagger, that he immediately went to the house of Ganesh, that he saw Ganesh lying in an injured state, and later Ganesh Basumatari died in hospital. What do you want to say in this regard? He has adduced false evidence. PW6, again PW6, again Basumatari has further deposed that when he asked Ganesh Basumatari, he said that you had injured him by stabbing with a knife. What do you want to say in this regard? I did not stab Ganesh with knife. PW7, Srimati Gogo Basumatari, this is the mother of the deceased, has deposed that at around 3-4 p.m. on a day around 3 years prior to her adducing evidence, she got information that you had stabbed Ganesh Basumatari with knife, that she immediately came house on getting the information and saw Ganesh lying on the courtyard. That when she asked Ganesh, he said that you had stabbed him with knife, and that later Ganesh Basumatari died in hospital. What do you want to say in this regard? I do not know about it. PW10 Sri Bolenboro had deposed that on the day around 5 years prior to his adducing evidence, he heard that you had killed Ganesh. What do you want to say in this regard? I do not know. PW11 Sri Shameshwar Kalita has deposed that during the investigation on 7/9/2009, he arrested you. And when he interrogated you, you showed in Tengas Nursery's house the dagger with which you committed the occurrence, and that he seized the dagger in presence of the witnesses. What do you want to say? He has adduced false evidence. What was the issue over which the quarrel took place between you and Ganesh? There was no quarrel between us. From where did you get the dagger? I do not know. Where did you go after stabbing Ganesh? I did not stab. You can adduce defense evidence, will you? I shall not. Do you have anything to say, anything else to say in connection with the case? Answer, no, I do not know why the case was filed. You do not know why the case was filed because he was all alone there. Now, Lordship, the judgment at page 32, it starts from page 32. The judgment dated 14/02/2019.
Page 38.
Page 38, Lord. I'm reading only the operative portion. Page 44, para 23. Down below, Lord. Now, on the above evidence point, number 9.1 is taken from the evidence on record. It reveals that none of the prosecution witnesses has seen the incident. The PWs in their evidence stated that they show the deceased lying on the ground in injured condition, and he was brought to Swagat Hospital, Bongaigaon, where doctor declared him dead. PW1, PW2, 3, 6, 7, and 9 were show injuries on the body of the deceased Ganesh Pasumata. They also show the blood was oozing from the injuries of the deceased. Regarding cause of death of deceased Ganesh Pasumata, the postmortem report is vital. From the evidence of PW12, it reveals that Dr. Avani Kalita did postmortem examination on the dead body of the deceased Ganesh Pasumata. Dr. Avani Kalita could not be examined as he left his job, and at present his whereabouts is not known to the authorities. Can it be possible? The RNB Civil Hospital authorities authorized PW12 to depose on his behalf, on behalf of Dr. Avani Kalita, as because he is acquainted with the handwriting and signature of Dr. Avani Kalita. From the exhibit 5, it reveals that during postmortem examination, Dr. Avani Kalita found the following injuries. There is a large bone deep cut injury around right shoulder, approximately 10 into 3 centimeters high, with the underlying bone. There was muscle deep cut injury of approximately 3.2 centimeters high, around right eye below. There was a bone deep cut injury approximately 5 into 2 cm, 3 size, around right shoulder. There was a large split open cut injury of 15 into 5 centimeters high, extending from right infamy area to the right costal margin. Injury up to a thoracic cavity. There is a large 10 into 3 centimeters size, approximately wound around supraumbilical region, therefore an explanation of omentum and bonen. There are blood clots in both nostrils and mouth. After examining the dead body, deceased Ganesh Patwari, Dr. Avani Kalita opined that the cause of death is due to immense shock and hemorrhage due to right and lung injury, that is homoparterium and bowel injury, along with head injuries sustained due to homicidal assault and are antemortem in nature. The defense side has not challenged the homicidal death of the deceased Ganesh Patwari. Moreover, on going through the exhibit 2 and case report, it reveals that At the time of inquest, following injuries were detected. Cut injury around right arm, about 2.5 inches long size. Cut injuries on chest measuring 3.5 inches long size. Cut injury on upper abdomen about 1.5 inches long size. Cut injury on the palm of right hand measuring 1.5 inch long. Cut injury on the waist measuring 1.5 inch long. And the injuries were caused by sharp weapon. There are ample corroboration among the witnesses regarding the injuries of the deceased. The defense side also had not challenged the homicidal death of deceased Ganesh Basumatari. The postmortem examination report reveals that deceased Ganesh Basumatari died due to injuries sustained by him. Therefore, I have nothing to hesitate to hold that Ganesh Basumatari was due to his sustained injuries and his death was homicidal. Now, paragraph 24. Next point, number 9 to Roman 2 is taken for decision. From the evidence on record, it reveals that none of the prosecution witnesses has seen the incident. PW1 is the informant of the case. PW1 in his evidence revealed that on 3/9/2009 at about 5 p.m. he was at Disney, and at that time his mother Sojala Basumatari, that is PW9, informed him that the accused Lena Basumatari stabbed his father with dagger. Immediately he arrived at his house, and before his arrival, his father was brought to Swagat Hospital by 108 ambulance. And thereafter, he got information that his father died. Thereafter, he lodged the FIR. From the evidence of PW2, it reveals that he heard that a quarrel was taking place between the accused Lena Basumatari and deceased Ganesh Basumatari. And accused Lena stabbed Ganesh with a knife. PW3, in his evidence, also stated that son of Ganesh informed him that accused Lena killed his father by stabbing with a dagger. PW4 in his evidence also stated that he got information that accused Lena Basumatari stabbed Ganesh and with a dagger. And after getting information, he went to the house of Ganesh and showed the dead body of Ganesh. PW6 in his is the neighbor of the deceased and accused person of the deceased and accused person. PW6 in his deposition has deposed that on the day of occurrence, he was at his home, and about 4 p.m. he heard that accused Lena Basumatari stabbed Ganesh with a dagger. He immediately went to the house of the Ganesh and saw Ganesh was lying in injured condition, and he saw cut injuries on the chest of the Ganesh, and blood was oozing from the injury. He asked about the incident, and he told them that accused Lena caused his injury by stabbing with a knife. And at that time, there were gatherings of several people. PW7 in her deposition has deposed that on the day of occurrence at about 3-4 p.m., she was at Lucky Bazar. At that time, Sumitra informed her that accused Lena Basumatari stabbed her son Ganesh by a knife. She immediately came to her house and saw Ganesh was lying in the courtyard in injured condition, and blood was oozing, and at that time he was in a position to speak. He asked Ganesh, and he told them that the accused Lena stabbed him with a knife. PW10 in his evidence stated that villager told him that the accused Lena Basumatari alias Goyari killed Ganesh Basumatari. PW9 is declared as hostile witness by the prosecution. Though she was declared as hostile witness, but she, in her examination, she stated that on the day of occurrence at about 4-5 p.m., he went to nearby river to take bath. After taking bath, she returned to her house and saw her husband in a serious injured condition nearby her house, and her husband was at that time alive, and asked her to give her water. But when she came back with the water, her husband was not in a position to speak. He was brought to Swagat Hospital at Bongaigaon, and in the hospital he expired. So from the evidence of PW 1, 2, 3, 4, 6, 7, and 10, it reveals that they heard that accused Lena Basumatari stabbed deceased Ganesh Basumatari. Though PW9 declared as hostile witnesses, but from her evidence, it reveals that after the incident, deceased was able to speak for some moment, and thereafter he could not be able to speak, though he was alive. From the evidence of PW6 and 7, it reveals that after the incident, they went to the place of occurrence and they found the deceased in injured condition. And on being asked by them, deceased told them that accused Lena Basumatari stabbed him with knife. So it appears that deceased before his death lastly speak with PW6 and 7 as to his cause of injury, which resulted his death. So this version can be used as oral dying declaration of the deceased Ganesh Mathari. Before we take consideration of the said oral dying declaration, we would go through the provisions of Section 32 of the Evidence Act. Section 32 of the Evidence Act provides as follows. Case in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. Statement written or verbal of relevant fact made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense under the circumstances of the case appears to the court unreasonable and themselves irrelevant. Page 50, Lordship, paragraph 29. Paragraph 29. From the ratio of the aforesaid decision of the Honorable Supreme Court, it reveals that acceptability of dying declaration has to be judged and appreciated in the light of the circumstances of each case, and it has to be weighed by reference to the principles governing the weighing of other evidence. Since the dying declaration is not made on oath, and the maker of the dying declaration cannot be subject to cross-examination, the court order to be on guard while testing the reliability. The court has also the obligation to closely scrutinize all the relevant attendant circumstances while testing its reliability, truthfulness, and as well as the voluntariness. It is not always necessary that the court, for the purpose of recording conviction on the basis of the dying declaration, has to look for corroboration. Looking for corroboration is a rule of prudence only, and if there is some doubt in the mind of the court, it may look for corroboration before recording the conviction. However, if the court finds certain infirmities in such dying declaration, which renders the dying declaration so infirm as to treat the consequence of the conscience of the court, it may refuse to accept the same as the basis for conviction. Here also, Lordship, PW 6 and 7, their statement, they say that so-and-so has informed that Lena has stabbed Ganesh. But the person, those who has informed, they were not examined, which was the vital witnesses. Because this Sumitra, the PW 7, what she stated, that she was informed that Lena has stabbed. That you can presume that Sumitra was an eyewitness. Why they were not examined? And the in front of PW 6 and 7, when the deceased has stated that Lena has stabbed, there were other people were there. So how other people were there? They were not examined. They should have been examined to corroborate. But here the dying declaration, there is no declaration at all. The question of dying declaration does not come, Lordship. The PW 6 and 7 statements are extrajudicial statements which cannot be relied. If your Lordship comes to page 63, that's the list. I, SI Sunashir Kalita of Bijni PS, do hereby seize the following articles which is recovered from the house of Tenga Najari, son of late so and so Najari, village so and so, PSBSD, district Chirang, as shown and led by the accused Nena Goswatari, alias Nena Goyari, of number 2 so and so, in connection with the above reference case in presence of the undersigned witnesses. One dagger, the length of which along with the handle is around 16.5 inches. The iron part of the rod is 12 inches long, and the length of the portion of the wooden handle is around 4.5 inches. These are the signature of the seizure witnesses. Now, Lordship, here the dagger was recovered from the house of Tenga Najari. In his deposition by the Tenga Najari, he has deposed that dagger was found in his house. In cross, he told that dagger was found nearby his house. So material contradictions are there, Lord. BW8 has stated that the blood sticking in the dagger, blood was sticking in the dagger. Whereas I was told that there was no blood stick. No fingerprint was taken. So how come the learned court bill has came to the conclusion that the accused has stabbed? There is no circumstantial evidences is there. There is no nothing is there. No eyewitness is there. The presumption is absolutely baseless. There is no dying declaration in my humble submission, Lord. It cannot be declared as a dying declaration. So I beg to refer to rely some judgment, Lordship. Even here, Lordship, my Lord Justice Malasrino was one of the judges in passing this order. In Criminal Appeal 46 of 2021, this is Criminal Appeal 46 of 2021. Mohammad Hafizur Rahman versus State of Saman. I take your Lordship to directly to page paragraph 32 at page 18. Law is well settled that dying declaration can be the sole basis for conviction if the same is found to have been recorded in accordance with law and appears to be truthful and voluntary. In the case of so-and-so, reported in 2021 6 SSC 213, it has been held that recording of dying declaration in presence of judicial or executive magistrate was not compulsory. It is only a rule of prudence, and if permitted by the facts and circumstances of the case, it should preferably be recorded by a judicial or executive magistrate so as to muster additional strength to the prosecution case. On the evidentiary value of dying declaration, the Supreme Court, after considering a number of previous decisions on the issue, had further observed that when the dying declaration has been recorded in accordance with law, it gives a cogent and turning to the evidence led by the prosecution. We have noticed that the informant Guddu Ali, that is the brother of the deceased, was examined as PW1. The witnesses has deposed that his elder sister Mamta got married with the accused Hafizur Rahman. After about 4 months of the marriage, the accused has demanded an amount of rupees 1,50,000 as dowry from the family. Since they were poor people, hence they could not give money. As a result of which the accused has assaulted his elder sister. On the date of the incident at around 2 p.m., the accused had assaulted his elder sister's victim. Then his sister poured kerosene on her person, believing that the accused would specify her. She was waiting, but instead of doing so, the accused had said, "Die if you intend to die," and thereafter lit a matchstick and set his sister on fire. When they got the information about the incident from the neighbors, his elder sister was taken to the civil hospital, and from there, the Lower Assam hospital, PW1 has stated that since he was busy with the treatment of his sister, the FIR was lodged after 5 days. PW1 has also stated that his sister victim had made statement before the police while she was some consciousness. According to this witness, police has also videographed her statement. The witness has proved Exhibit 1 as the AJR lodged by him, and has further stated that the police had seized Kabinnama, an agreement of marriage executed before the notary by means of seizure list. Exhibit 2, Exhibit 3 is the inquest report which he has signature. During cross-examination of PW1, he realized that the deceased was his only sibling. Explanation of the occurrence that court can rely upon, as it is the solitary piece of evidence to convict the accused. Paragraph 33. Lord. As noted here in above, the dying declaration in this case was recorded by the IO PW13. From the careful examination of the dying declaration in the light of evidence brought on record, the following facts have been observed. The dying declaration was recorded by the IO during the course of investigation without obtaining any certificate from the doctor as regards the mental and physical state of the victim. The same would bear special significance since it has come out from the medical evidence that the victim had suffered severe burn injuries on various parts of the body, including her face, stomach, and chest. The dying declaration of the victim was recorded 4 or 5 days after the incident when she was undergoing treatment in the hospital. During that period, in all likelihood, the victim was under the influence of various drugs, including painkillers. She died within 2 days thereafter due to septicemia. Under the circumstances, it is doubtful that the victim was actually in a proper physical and mental condition to speak. So here also, Lordship, the deceased was not in a position to speak. PW6 and PW7, it means cannot be relied upon, and this is not a diagram, in my humble submission. And subsequently, the appeal was allowed, Lordship. Now I'll take you. 2019-6 Supreme Court SCC 145 Punam Bhai for the state of Chhattisgarh. 2019-6 SSC 145. I've given the citation. Enter.
Yes.
Lordship, take your Lordship to paragraph 10. There cannot be any dispute that a dying declaration can be the sole basis for convicting the accused. However, such a dying declaration should be trustworthy, voluntary, blemishless, and reliable. In case the person recording the dying declaration is satisfied that the declarant is in a fit mental condition to make the statement, and if there are no suspicious circumstances that the dying declaration may not be invalid solely on the ground that it was not certified by the doctor. Instances for certification by the doctor is only the only rule of prudence to be applied based on the fact and circumstances of the case. The real test is as to whether the dying declaration is truthful or involuntary. It is often said that man will not meet his maker with a lie in his mouth. However, since the declarant who makes a dying declaration cannot be subjected to cross-examination, in order for the dying declaration to be the sole basis for conviction, it should be of such nature that it inspires full confidence of the court in the matter of hand. Since Exhibit P2 is the dying declaration is the only circumstances relied upon by the prosecution in order to satisfy our conscience, we have considered the material on record, keeping in mind the well-established principle regarding the acceptability of the dying declaration. Now, paragraph 14, Lordship. 14B. Oh, sorry. B16. Paragraph 16, 17. As far as the oral dying declaration is concerned, the evidence on record is very shaky. Apart from the fact that evidence relating to oral dying declaration is a weak type of evidence in and of itself. As per the case of the prosecution, the deceased had made a oral dying declaration before Lalita Shahu PW2, so-and-so PW3, so-and-so PW4, and others. Though PW2, 3, and 4 have deposed that the deceased did make an oral dying declaration before them, implicating the appellant, the version is clearly only an afterthought, inasmuch as the same was brought up before the trial court for the first time. In their statement recorded by the police under section 161 of the Code of Criminal Procedure, these witnesses has not made any statement relating to the alleged oral dying declaration of the deceased. These factors have been noted by the trial court in its detailed judgment. Thus, the evidence of PW2, 3, 4 relating to the oral dying declaration is clearly its improved version. This is very important, improved version. And this has been proved by the defense in accordance with law. 17 law. Since the evidence relating to the dying declaration has not been proved beyond reasonable doubt by the prosecution, in our considered opinion, the High Court was not justified in convicting the appellant inasmuch as there is no other material against the appellant to implicate her. The motive for the offense as alleged by the prosecution has not been proved. So see, here also, this is absolutely of our case law. Here also, this is there's a paragraph 17, Lordship. Again, I'm reading. Since the evidence relating to the dying declaration has not been proved beyond reasonable doubt. Here also, it was not proved beyond reasonable doubt by the prosecution. In our considered opinion, the High Court was not justified in convicting the appellant, in as much as there is no other material against the appellant to implicate her. The motive for the offense as alleged by the prosecution has not been proved. Here also, motive has not been proved. I respectfully submit before Lordship that Lordship may be pleased to accuse the accused person, because he was he's under he's in custody. He's in custody now, Lord. Since after 3 months he was released on bail. Thereafter, after the passing of the judgment, impugned judgment, he is under behind the bar. This is my respectful submission.
My lord, my senior means is on her legs in court number 3. Lordship, she will come, Lordship. Name the Lordship. Lordship, may kindly pass over the time being, Lordship.
Like that. You can't take up cases piecemeal.
Pardon, Lordship.
We can't take up piecemeal cases. Yes, argued the matter, now it's your turn to argue.
She will come, Lordship. My senior means you will come, Lordship. Please don't take action.
No. Good.
After Sunday.
We'll fix it on
Tuesday, let it be part of Lordship.
Yeah. You amicus curiae?
No. I'm. We have been engaged. Earlier, it was America's case. We were engaged, Lord.
Yeah.
Deeply on
Part-
Item 8 and 9.
Lordship, I am on behalf of Mr. N. Deka, the amicus curiae.
Hmm.
He'll be coming in a few seconds, Lordship.
We'll fix it some other. One.
Then
Obliged.
May I please, Your Lordship? This is appeal against acquittal, my lord.
Yeah, we'll fix it next week. Today, there's no time.
Yes, I know.
Heard Mr. J.C. Bora.
P. Kotokin.
Oh, sorry. He got a kill and also for the appellants. Also heard. Who's appearing?
PP is appearing and Mr. Borbora, AC Borbora, he is appearing for respondents, my lord. His name has been shown, my lord. The cause list, my lord.
And Mr. A.C. Barbara, Leonard Counsel for the,
Respondents, my lord. There is a accused persons, my lord.
okay. And the public prosecutor?
I think Ms. Ezdahan,
Boyan.
Ms.
Ezdahan,
Yes, John. Also, John, with additional PP. For the state of Assam and Mr. A.C. Barbara, Leonard Counsel for the respondents. List the matter after 1 week.
Your lordship has fixed a date.
No, not fixing a date. You never know what will happen.
Right.